May I mention a testamentary matter? Testamentary matter. Probate has been granted, assets have been all collected, and distributions and allocation to the beneficiaries are all made. Only thing remaining is my lord filing investment accounts.
When the probate was granted?
Probate granted 13 December 2018 and issued on 27 January 2020. And that is the COVID period in that 2 years. So
have you filed an application? Have you filed an application for extension of time for filing affidavit of assets?
No, my lord.
Then how it can be granted? Come with an application. Come with an application showing the cause why you have not submitted all these things. We'll see to that. File pen.
My lord, my application, my lord, under Order 7, Rule 11, my lord, Clause D of the Civil Procedure Code, my lord. My lord, for the reasons that, my lord, the whole cause of action, my lord, is barred by the laws of limitation, my lord.
Barred by limitation?
Yes, expressly. Now, kindly takes, my lord, the plaint for once, my lord.
The money claim?
Money claim in the nature of damages, my lord. My lord, the plaint starts, my lord, from page 11, my lord, of my application. Now, my lord, your lordship will find, my lord, from the plaint itself that there is an amendment and I have been incorporated, my lord, in place of syndicate bank. Now, my lord, the plaintiff's case, my lord, in brief, my lord, is the plaintiff was acting as an agent, my lord, on behalf of the bank, my lord, which was syndicate bank, my lord, prior thereto, for disbursing, my lord, loan to, my lord, various farmers. My lord, as a matter of security, my lord, those farmers, my lord, certain, my lord, kgs of potatoes, my lord, were kept, my lord, in the cold storage of the plaintiff, my lord, for which, my lord, bonds were executed by the plaintiff as well as, my lord, with the farmers, my lord. Now, in turn, my lord, those bonds, my lord, were thereafter, my lord, given to the bank.
But the bank was a tri-party party?
No.
Third party?
Nothing has been disclosed, my lord, in this plaint, my lord, 7 except, my lord, a scheme, as well as, my lord, a letter which shows, my lord, that I have, my lord, provided them loan, my lord, directly of 123 lakhs, my lord. Now, my lord, I'll my lord, take, my lord, your lordship, my lord, through those, my lord, documents. For the time being, my lord, I am restricting myself, my lord, to the avertments of the plaint. Kindly give me. My lord, the plaint starts from page 11.
Yes. Which paragraph you are relying?
Yes, my lord. Lordship will kindly come straight away to paragraph, my lord, 8. In order to give effect to the executive intent of the government, the defendant bank framed a scheme known as Syndicate Kisan Samruddhi Credit Card SKCC scheme. My lord, this particular scheme has been annexed, my lord, to the plaint, my lord. Thereafter, kindly seize, my lord, paragraph 10 for once, my lord. My lord, my endeavor before your lordship is to show, my lord, the relationship of the parties, my lord, the contract or the agreement which my learned friend has pleaded in his plaint, and, my lord, the start of the cause of action, and, my lord, the first infringement thereto, my lord. Kindly takes, my lord, paragraph 10 for once. At all material times, the defendant further represented and or, my lord, held out to the plaintiffs that the defendant to implement its need and or directive with regard to disbursement of loans to small and marginalized farmers needed an agent through whom such loans could be disbursed to the said farmers. My lord, this is what I have submitted, my lord. Now, kindly takes, my lord, paragraph 13. The defendant bank was desirous of granting loans and credit facilities to such farmers, but wanted to make such disbursement through the agency of the plaintiff number 1, so that the defendant was not required to deal with a huge body and or a number of potato farmers. In the aforesaid circumstances, it was agreed and decided by and between the parties hereto. My lord, this was, my lord, the contract, my lord, between the parties. The defendant bank would grant credit facilities to the individual potato farmers. Such loan would, however, be disbursed by the defendant to the plaintiff number 1 as its agent. The plaintiff number 1 as the agent of the defendant would in turn disburse the credit facilities so obtained from the defendant to individual farmers. The security in respect of the credit facilities so disbursed to the farmers would be the potatoes stored by them in cold storage of the plaintiff number 1. The creation of pledge by the individual farmers in favor of the plaintiff number 1 would be in the form of bonds executed by individual farmers in the favor of the plaintiff number 1. Now, my lord, he also annexed, my lord, a sample bond. Now, my lord, kindly see the next. The bonds executed by the individual potato farmers would in turn made over and are assigned by the plaintiff number 1 in favor of the defendant to secure the credit facilities granted by the defendant to the plaintiff number 1 for onward disbursement of such credit facilities to the individual farmers. So, my lord, this is how, my lord, he, my lord, pleads the contract between the parties. Now, kindly takes, my lord, paragraph 14 for once. By its letter of sanction dated 3rd March 2008, the defendant inter alia sanctioned a limit of 126 lakhs in favor of the plaintiff number 1 on account of farmers' loan. The said letter of sanction dated such and such inter alia provided that the said credit facility would be secured by pledge of bonds and guaranteed by the company. Thereafter, my lord, kindly takes paragraph 16. It is manifest from an examination of the said letter of sanction dated such and such that the plaintiff number 1 was merely a guarantor of the said credit facility and was not the principal borrower in respect thereof. So, my lord, he says that the plaintiff number 1 was acting as a guarantor on behalf of the farmers, my lord, who in turn, my lord, have pledged the bonds, my lord, with the bank.
Correct.
Now, kindly takes, my lord, paragraph 19 for once. My lord, this is also, my lord, this is very important, my lord. The defendant duly accepted such bonds and expressly and or impliedly agreed to release such bonds as and when repayments were made and or offered. My lord, this is very important, to be made by the individual farmers, my lord. Now, my lord, if this is, my lord, the sum and substance of the contract, my lord, he says that, my lord, I was acting as the agency of the defendant bank. Now, my lord, according to him, my lord, this particular amount was disbursed to him, my lord, and was routed through him to the various farmers. By way of security, my lord, the bonds which were executed by, my lord, the potato farmers, which were kept, my lord, under the custody of, my lord, the plaintiff number 1, were actually assigned to the defendant bank. And, my lord, they also say, as and when repayment was made and or offered, the bond will be released. So, this is the sum and substance of the cause of action. Now, kindly takes, my lord, paragraph 22 onwards. This is his first letter of demand, my lord. He says, by numerous letters dated 1st September 2008, 5th November 2008, 4th November 2008, 19th February 2013, 18th November 2013, 30th July 2014. So, my lord, for the time being, lordship kindly sticks to, my lord, 1st September 2008, 5th November 2008, and 4th December 2008. So, my lord, he calls upon me to produce those bonds, my lord. Now kindly see, my lord, paragraph 23. In response to the repeated demands, request and or representation made by the plaintiffs for release of the said bonds, the defendant bank by its letter dated 22nd October 2008 stated that such request for release of the security bonds would be decided in accordance with the decision taken by the higher authorities. Miller, pausing here for a moment, Miller, I would like to show to your lordship, Miller, the relevant, Miller, documents which he relies upon, Miller. First September letter. Lordship kindly takes, my lord, page 95 for once. What was his demand? Your lordship will find, my lord, this is the letter of 1st September 2008.
Yes.
Your lordship will find, my lord, our earlier letters of such and such is there.
Yes.
Our CC account such and such is there. Permission for release of security bond of farmer loan. This is to reference of our earlier above mentioned letter. We once again pray to your kindly give us permission for release of security bonds of farmer loan. Market of potato is being gradually worse to worse condition. So kindly grant our prayer to recover maximum loan as much as can under these circumstances. We need your help urgently. Delay of permission may be adverse situation. So this is, Miller, let us consider for the time being, Miller, this is his first demand, Miller. Vis-a-vis, lordship kindly takes, Miller, page 108. Miller, I am, for the time being, Miller, I am not troubling your lordship, Miller, with the other, Miller, demands. 108, your lordship will find, Miller, this is the bank's letter of 22nd October 2008. Now kindly sees, payment of half yearly installment to your term loan such and such. Kindly refer to your earlier discussion with you regarding payment of half yearly installment of such and such towards the principal of term loan of such and such fallen due on such and such. We once again request you to pay the installment towards principal amount immediately. Regarding your request for permission to release the security bond of farmers loan, we request you to submit the report of SLBC, RBI or UBI to lead bank wherein any decision for mitigating the hardship of cold storage unit has been taken due to falling price of potato during this year. As soon as we receive any report from the competent authority apprising the fact and directing the financial institution to act upon it for taking suitable measures to mitigate the hardship of cold storage unit, we shall take up the matter with our higher authorities for taking any remedial measures. So therefore, my lord, by way of a letter dated, my lord, 22nd October 2008, my lord, there is an unequivocal infringement of right of, my lord, the plaintiff number one. Now, my lord, if I, my lord, kindly come back, my lord, if your lordship kindly come back to paragraph 20, paragraph 19 for once, my lord. My lord, his statement from the plaint shows that there was an express and or implied agreement between the parties here too, that as and when, my lord, repayments is made or any demand or any offer is made, the bank has to release, my lord, the bonds in question. Now, my lord, kindly takes, my lord, the other paragraphs of the plaint.
Where is the cause of action?
Yes, my lord. Kindly, my lord, I'll show that paragraph, my lord, where he has pleaded. But prior to this, my lord, what is his cause of action, my lord? I'll just indicate to your lordship, my lord. Kindly takes, my lord, from paragraph 24 onwards, my lord.
Yes.
In spite of issuing the said letter dated such and such, the defendant bank subsequently made a complete volte-face and blatantly denied having received the said security bonds. The defendant as the lender was all along in a position to dictate terms and not dominate the will of the plaintiffs, and accordingly by proper use of the superior bargaining power denied receipt of the security bonds. In addition thereto, by its letter dated such and such, the defendant bank unilaterally split up the said farmers loan account of rupees 126 lakhs into two sublimits of rupees 63 lakhs each, being such and such. Milord, I'm not troubling your lordship with the other. Now kindly takes Milord paragraph 27.
Yes.
The plaintiffs state that the new sublimit being WCTL, Milord, I believe this is working capital term limit. Working capital term limit, for rupees 63 lakhs could not have been secured by the said security bonds, and security bonds of proportional value of 63 lakhs ought to have been released and or made over by the defendant. So the second cause of action, Milord, first is, Milord, he says that the bonds has to be, Milord, returned back when a demand is made.
No, because the page paragraph 25 it stated that the bank has split it in two parts.
Yes.
126, that is the farmer's loan, and
that is
WCT.
in February 2009.
Correct.
So there is another infringement.
Yes.
Now kindly takes, Milord, paragraph 29. The direct fallout and or consequence of the refusal on the part of the defendant bank to release and to make over the said bonds was that none of the said potato farmers took delivery of the said potatoes, as the price of the said potatoes has fallen in the meantime, and the plaintiffs were saddled with the entire stock of the said potatoes. So, Milord, if there is, Milord, non-release of the bonds, Milord, and he has suffered this damage that has occurred, Milord, in the year 2008 itself.
Correct.
Now kindly see, Milord, paragraph 32 and 33 for once. The plaintiffs state that on or about November 29, 2012, the plaintiffs fully repaid the said WCTL amount of rupees 63 lakhs. By repaying the said to the defendant bank a sum of rupees such and such, this has been repaid by him. So, Milord, if the term loan was not to be repaid by him, he could have either, Milord, lodged a, Milord, proceeding against me, saying that this is against, Milord, what has been agreed between the parties. He has not done so, Milord. He has paid, Milord, in the year 2012.
Correct.
Now, even assuming, Milord, in 2012, Milord, he has suffered another damage. So 3 years, Milord. Now kindly takes, Milord. On or about September 2011, the plaintiffs also repaid in full, together with interest, cost and charges, the farmer's loan pledge account of rupees 63 lakhs. In respect of the said farmer's loan pledge account, the plaintiffs have repaid a total sum of rupees such and such, as will be manifest from a statement of accounts. Now kindly takes, Milord, paragraph 34. By its letter dated 23rd November 2016, written to the plaintiff bank, the defendant bank for the first time admitted and acknowledged the fact that the said security bonds were still lying with it. Though, Milord, manifestly, Milord, and from the records itself, Milord, it shows, Milord, there was a clear and unequivocal, Milord, infringement of his right by my denial, by the bank's denial, that I'm not going to give you the bonds until and unless you repay as to the extent what you have received, and, Milord, you need to show certain circulars to the effect, Milord. So there was a clear, unequivocal, Milord, infringement of his right.
Yes.
So, Milord, he falls back on the letter of 29th, on the letter of 23rd November 2006, Milord, and that this is how, Milord, he, Milord, corroborates his, Milord, cause of action, the first cause of action.
The 2016 letter, kindly go to the contents
Yes,
regarding
Milord.
chapter 2. We have found the bunch of bonds
One.
up to
Kindly takes, Milord, page 127 for once.
Yes.
Kindly takes, Milord, the present outstanding position of the account furnished as under SODH. This is account is overdue. So this particulars are there. Milord, we have for reference your representation regarding your SODH term loan accounts with your branch. You have requested that certain credit facilities were sanctioned by the branch against pledge of bonds of potatoes stored in your cold storage. Subject pledge loan have already been closed in 2009.
Correct.
Further, WCTL and OTH limits were sanctioned as per request of the company. You have mentioned that certain losses were incurred by the company for pledge of the said potatoes. The aforesaid matter was examined in detail during the meeting of such and such in presence of a regional office, the company official, branch official. After a threadbare discussion, it was concluded that the facility was closed. The other credit facilities of the company was restructured and or renewed in subsequent years with fresh documentation. The terms and conditions of the succeeding sanction letters were duly accepted by the company. The contention of incurring loss relating to the pledge of potatoes in 2008 is a business loss to the company for which the bank is not responsible.
Correct.
So, my lord, this has been made in 2016. Had there been a business loss, my lord, let us, my lord, for the time being, consider this as a letter of acknowledgement of his dues, my lord. It has to be made, my lord, within the period of limitation.
No, that's correct. With regard to the damage, that 2008, they have concluded this, they have informed nothing.
Yes.
But your bank has kept pending for taking decision. In 2016, a decision was taken, a meeting was held with regard to the subsequent sanction was allowed, and some further documents were executed. Correct. So whether it cannot be said that it is a continuous cause of X.
My lord, in my humble and respectful submission, my lord, it is not, because for the simple reason.
Your bank has admitted by the letter dated 23rd 11/6.
My lord, this at best can be considered as an acknowledgement of his dues, the
Correct.
acknowledgement of a dual relationship, the
Correct.
acknowledgement of a fact that, my lord, the bonds were kept with me. I have to return it. At best, my lord.
Correct.
These acknowledgement, my lord, had this been made, my lord, within the 3 years from 2009, my lord, obviously my order 7, rule 11 wouldn't have, my lord, any legs to stand on, my lord.
Okay.
But the fact which this has been made in 2016, my lord, shows.
Then second paragraph regarding pledge potato bonds, we have found the bunch of bonds after searching the old files.
Yes, since the matter is now more than 8 years old, we
Yes,
request
sir,
you to
very
verify
good.
the same and take delivery.
Correct.
Yes. But what is his cause of action with regard to the plaint?
With regard to with regard to the plaint, he is claiming certain compensation, certain amount from you with regard to no, the price of the potatoes has gone down, farmers are not taken, and you have not released that bonds and all these things. What he has made out the case. But you have kept the matter open till 2016, and by way of a letter, you have agreed for that.
No,
Now,
my lord, kindly takes, my lord,
with regard to
page, it starts from page 19, paragraph 41. Now, this is his particulars. My lord, had there been, my lord, a cause of action with regard to, my lord, the bonds, of course, my lord, within limitation. But over here, what is he praying? He has paid, my lord, the sum which he has paid to the farmers. And, my lord, kindly takes note of the fact, my lord, he has, my lord, calculated interest from 1st September 2008.
where from you are reading?
Lordship kindly takes, my lord, paragraph 41.
Hmm.
It starts from page 19. Lordship
Correct.
kindly takes, my lord, page 34.
Yes, yes.
The particulars is there.
Principal sum paid to the farmers.
Yes.
2 crore so
Right.
interest calculated from it.
On and from 1st September 2008.
Yes.
So his cause of action, my lord, has accrued, my lord, in 2008.
Correct.
Latest by 2009. When is my denial, my lord?
Yes. When the suit was filed?
This has been filed in the year 2018.
2018.
Yes. And, my lord, kindly takes, my lord, the other prayer. Paragraph 44. In addition to the above, the plaintiffs have suffered enormous losses on account of loss of business, loss of reputation and goodwill, loss of rental charges for cold storage, and distress sale of the said cold storage. The plaintiff reasonably assess such loss and damage to be a sum of rupees 3 crores. My lord, kindly takes, my lord, loss of rental for cold storage and distress sale of the said cold storage. That, my lord, he has, my lord, stated in paragraph 38. My lord, when he has sold, my lord, the cold storage, The plaintiffs under coercion and duress from the defendant bank had to sell the cold storage for a distress and throw away price of 7 crores.
Correct.
Now, my lord, he also annexed, my lord, that has been done in the year 2012, my lord. So at best, my lord, at best, it had to be filed within 2015, my lord. Until and unless, my lord, they show, my lord, there is some kind of acknowledgement in writing, my lord, within the period of limitation. Some kind of, my lord, acknowledgement. Now, my lord, now this is very interesting, my lord. Paragraph 46.
Yes. Yes.
The cause of action of the plaintiffs arose for the first time on 23rd November 2016, when the defendant for the first time admitted that the said bonds were lying with it. My lord, he purposely uses the word for the first time. Now kindly takes, my lord, I'm not troubling your lordship with the other, my lord, sentence. Kindly takes, my lord, page 36.
The cause of action.
Yes, the cause of action thereafter arose on 8 March 2012. My lord, if it had arisen, my lord, for the first time in 2016, then it wouldn't have arisen in 2012 and 8 March and 7th March. This is absolutely, my lord, a clever drafting, if I may say, my lord. And for this, my lord, your lordship has to consider a meaningful reading. Your lordship has to consider the documents from the plaint itself. Now, my lord, let us consider, my lord, the various articles, my lord, of, my lord, the Limitation Act. Lordship has that a Limitation Act. Ache. Lordship kindly takes, my lord, Article 27.
Yes.
Now, from the awardments of the plaint, it is absolutely clear that, my lord, the cause of action have arisen in the year 2008 itself, or in the year 2012. Had there been, my lord, an infringement of my learned friend's, my lord, client's right, my lord, he would have come before your lordship, my lord, in the year 2012 when he had to repay, my lord, the farmers.
See, you have used the clever drafting. The advocates, they choose which are the document will save them, so they will press that document first. That's why he has used the 2016
Yes.
first, then he has come
Yes.
to the 2012
Yes.
subsequent.
And kindly see, my lord, the use of the word for the first time.
Okay.
Now kindly takes, my lord, Article 27 for 1. My lord, this is in the nature of compensation. For compensation for breach of a promise to do anything at a specified time or upon the happening of a specified contingency. 3 years from when the time specified arise or the contingency happens. So, my lord, if this article, my lord, is applicable, it is, my lord, the first letter of demand which they have given in the year 2008, and, my lord, the infringement in the year 2009 when the bank has said, my lord, that I'm not going to give you back the bonds. Now kindly takes, my lord, this is more, my lord, certain, kindly takes, my lord, another provision, another article rather, my lord, Article 55, more of a general, my lord.
That always.
Yes, more for compensation for the breach of any contract express or implied not herein specifically provided for. So, my lord, I say, my lord, Article 27 will apply. If your lordship is not with me, then of course, my lord, Article 55, because it is a general, my lord, article. It says, my lord, when the contract is broken or where there are successive breaches, when the breach in respect of which the suit is instituted occurs or. So it is your lordship has to consider the praise of the plaint. The praise of the plaint suggests, my lord, he is asking for money which he has paid to the farmers. That,
So-
my lord,
So 55 naturally is from the date of denial.
yes, from the date of denial, or at best when he had to repay the farmers. That is in the year 2009 itself. Another provision, my lord, another article which, my lord, of course, my lord, if my learned friend, my lord, satisfy your lordship, my lord, that both of this article would not apply, then, my lord, in that event, 113 for once. Any suit, lordship has got it?
Yes.
Any suit for which no period of limitation is provided elsewhere in this schedule, 3 years when the right to sue accrues. Not right to sue means,
But 113 will not affect because the part 2 is relating to the contract and his
Yes.
suit based on the contract.
yes. If my learned friend, my lord, satisfy your lordship, my lord, that both of those articles would not
He
apply.
cannot
Then in
say.
that event,
He cannot say because this is the
contract.
If it's
I'm
a
grateful to
contract,
your
then the
lordship.
part 2 will come.
I'm grateful to your
The
lordship.
part 2 will come, the 27 and what?
I'm grateful to your lordship. Now, my lord, the other point is, my lord, he has instituted this suit, my lord, under the commercial division. Now, kindly takes, my lord, his prayers for once, my lord. I believe, my lord, there is no, my lord, urgent application, my lord, filed by them. Any interim urgent application. Now, kindly takes, my lord, the press. The plaintiff claims there is, my lord, no, my lord, there is no, my lord, prayer, my lord, where the pre-institution mediation, my lord, he's trying to bypass, or my lord, he says, my lord, that he needs to, my lord, file an urgent interim application. So therefore, my lord, I need not, my lord, go before the mediator. My lord, this suit has been filed in the year 2018. Now, kindly takes, my lord, the affidavit portion for once, my lord. This has been affirmed on 20th June 2018. So must be, my lord, after 20th June 2018 that has been filed. So, my lord, kindly takes, my lord, commercial code sector 12A for once. This, your lordship will find. Lord,
Yes, it is.
kindly, kindly take notes of the fact, my lord, that, my lord, 12A has been inserted with effect from 3/5/2018. My lord, much prior, my lord, to the filing of this suit, my lord.
But we have to govern by the Lakshmi Polyfab and
Lakshmi
the
Polyfab,
Patil
yes.
Automation.
Yes, it's mandatory. Patil Automotive says, my lord, it is mandatory.
Mandatory, but if it is filed when our
So therefore, my lord,
the notification of our court when it was come.
yes, my lord. Let us, my lord, for the time being consider, my lord, that the mediation center, my lord, in one of those judgments, my lord, of Justice Devanshu Boshak itself, my lord,
That's why that is the Lakshmi Polyfab.
Lakshmi Polyfab, and yes, and other judgments are there, my lord. It says, my lord, that from December 2018, December 2018 or 2020,
Doubt to that.
Huh?
2018 or 2020, there is some doubt.
I believe,
Because
my lord,
August
2020, my lord.
Patil is August 2022.
Yes,
And this Lakshmi Polyfab, let me see.
my lord. Let us, my lord, for the time being consider, my lord, that mechanism was not present.
No,
my
if
lord,
it is mechanism was not available, this court,
yes,
then he cannot be said that he should not be non-suited.
right. But, my lord, the fact remains that 12A was mandatory.
It is mandatory.
Right. The moment I say, my lord, it was mandatory, it was my upon my learned friend, my lord, to plead in his plaint itself that, my lord, the mechanism was not there. So therefore, I am not entitled to go before the pre-institution mediation, and therefore I can straight away file, my lord, this instance. So, my lord, those avertments are not there. Those avertments are not there.
That will suit. That I will see.
Now, my lord, these are, my lord, the two aspects, my lord. Now, my lord, 3-4 judgments, my lord, on the point.
Yes.
2020, yes.
2020, my lord.
Yes, 2020.
There is some confusion. Lakshmi Polyfab.
My lord, প্রথমটা হচ্ছে 1977
ইয়ে কপি দেবো তো?
আছে, কপি আছে আর একটা, হ্যাঁ আদার সাইডে আচ্ছা 97 টা দাও। Milord, the first decision, Milord, is 1977, volume 4, Supreme Court cases, page 467. Lordship kindly takes, Milord, paragraph 5, Milord, straight away. Milord, this has been, Milord, this is in relation to, Milord, clause A, Milord, of order 7 rule 11, but nonetheless, Milord, Milord, the same principle would apply. Kindly takes, Milord, paragraph 5, Milord. We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and are unrepentantly resorted to. From the statement of the facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Municipal Bangalore is a flagrant misuse of the mercies of the law in receiving the case. The learned Munsif must remember that if on a meaningful, not formal, reading of the plain, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue. He should exercise his power under Order 7, Rule 11, CPC, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the party searchingly under Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. The trial courts would insist imperatively on examining the party at the first hearing so that bogus litigation can be shot down at the earliest stage. So, Milord, what I'm trying to say is, Milord, your lordship has to give a meaningful reading of the plain. So, Milord, this is
the
Milord,
only thing
Yes.
with regard to the limitation, it cannot be said that it's a mixed question of facts and law.
Milord, I understand what your lordship, Milord, what is going through your lordship's mind,
But
Milord.
the
Perhaps,
limitation,
Milord-
it is not the straight formula jacket. If it is to be taken into consideration of the facts and the law,
Milord,
fact has to be, because the whole plaint has to be read together.
Yes. That is the principle, Milord, underlining. And in fact, Milord, I will show, Milord, another judgment which says, Milord, in case of limitation, your lordship has to, Milord, consider the, Milord, documents as well, Milord.
No, that can.
Now, Milord, what I have understood correctly, since it is a mixed question of law and fact, Milord, so there can be, Milord, a benefit of doubt, Milord, given to the plaintiff in that event. Milord, in my humble and respectful submission, Milord, from the reading of the plain, from the plain reading of the plain, let us consider for the time.
That's why
being
the
from-
whole reading of the plaint.
Yes, along with the documents, the lordship has to consider when was the first time the right was infringed. Is there a continuous breach? In my humble and respectful submission, Milord, in the instant case, there is no continuous breach. It is, Milord, restricted to two cause of action. One is, Milord, that he had repaid the farmers. When he has repaid, when his right was infringed, had there been an infringement of right, he would have straight away come before your lordship and file a suit, Milord, for compensation. He has not done so. He has paid to the bank.
No,
Thereafter, Milord,
that you shown.
yes. The next, Milord, decision is, Milord, 2004, volume 3 SCC, page 137. Milord, paragraph 8 onwards, Milord. Milord, in the present case, the respondent trust has relied upon clause A and D of Rule 11.
Bar under law.
Yes, bar under law.
Under the trust act.
It's, Milord,
Under the trust act, the suit.
no, not only that, A and D of clause 11.
That's why clause 11 of the CPC, because
Yes.
bar under law, the
Law.
suit is.
Yes, and as well as, Milord, the limitation. Limitation was, Milord, also. Then, Milord, your lordship will find that from paragraph 10, 11, 12, there are certain judgments which I'm not troubling your lordship with, my lord. Lordship kindly takes, my lord, paragraph 15. There cannot be any compartmentalization, dissection, segregation, and inversion of the language of various paragraphs in the plaint. If such a course is adopted, it would run counter to the cardinal canon of interpretation, according to which a pleading has to be read as a whole to ascertain its true import. It is not permissible to call out a sentence or passage and to read it out to the context in isolation, although it is the substance and not merely the form that has to be looked into. The pleading has to be construed as it stands without addition or subtraction or words or change of its apparent grammatical sense. The intention of the party concerned is to be gathered primarily from the tenor and terms of his pleadings taken as a whole. The same time, it should be borne in mind that no pedantic approach should be adopted to defeat justice on hair splitting technicalities. So the next decision is, my lord, 2020. This is more of a recent decision, my lord, on the same principle, but nonetheless, my lord, paragraph 23 onwards. But what is German in this, my lord, the ratio which has been laid down in your lordship will kindly takes, my lord, for once, my lord, paragraph 23. The same principle would apply, and it is reiterated over here itself. Yes, kindly consider, my lord, paragraph 23.11. My lord, this is, my lord, the answer, my lord, to your lordship's question, my lord, whether, my lord, they will get a benefit of doubt or not.
Yes.
The test for exercising the power under Order 7, Rule 11 is that if the avertments made in the plaint are taken in entirety in conjunction with the documents relied upon, would the same result in a decree been passed? So, my lord, your lordship, under the Limitation Act itself, my lord, your lordship knows, my lord, section 3, it is the primary duty casted upon the court, my lord, to see whether it is. Yes. Now, my lord, had there been, my lord, a plaint taken as a whole with the documents, would there be, my lord, a decree passed? So the question of limitation then and there, my lord, arises.
That is one of the reasons.
Yes. Now kindly takes, my lord, paragraph 28 for once. A 3-judge bench of this court in state of
28.
Paragraph 28 at page 381.
Yes.
This is what is important. Held that the court must examine the plaint and determine when the right to sue first accrued to the plaintiff and whether on the assumed fact the plaint is within time. The words right to sue means the right to seek relief by means of legal proceeding. The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the suit is infringed, or when there is a clear and unequivocal threat to infringe such right by the defendant against whom the suit is instituted. Order 7, Rule 11D, my lord, which considers, my lord, the point of limitation, provides that where a suit appears from the avertments in the plaint to be barred by any law, the plaint shall be rejected. So, my lord, these are, my lord, the basic things, my lord, which I want to, my lord, portray before your lordship, that the plaint, my lord, ex facie, from the, my lord, avertments of the plaint, it suggests, my lord, the first, my lord, cause of action or the infringement have arisen in the year 2008, latest by 2009, or in the year 2012. There is, my lord, no acknowledgement within such time. First, he relies upon 2016. He says, my lord, for the first time, and thereafter, my lord, he reverts back, my lord, to the, my lord, in the year 2012 and on. So, my lord, it has to.
Thank you.
The bombarding by my learned friend has waffled both of us, my lord. May we come back and in the meantime we file our affidavit.
You are plain.
I know.
So what further?
We need to consider the judgments also, and we need to file the affidavit.
Affidavit. Now,
What? Hearing
Opposition to this, my lord, the order 7
hearing
to
can
11.
be read. You
I have
close it
already-
every time. You have not asked for the time. You have kept
Mr.
silent.
Mr. Ghoshal walked in and started the argument in such a flow, my lord. I did not
He-
wish to
he
interrupt
have
him.
asked at the
You have been asked. Because
Within a week, and my lord keeps it on reopening, my lord, we shall come back.
this is not fair.
But
Well,
we need to
could have
consider
started my argument.
we need
Milord.
to consider
Started
the
the argument. I am taking note of that. You could have.
no, we need to consider the judgments.
You considered it. I am not telling you argue that. I am giving the time with regard to the opposition already. And this is point of law.
Very well,
We cannot.
very
because
well.
I mean, not in
What the order 7
only
rule 11 cannot go by.
beyond the pleadings, beyond the
What is the
claim.
pleading? How you cannot improve with regard to the affidavit
I
of
can't.
opposition. Whatever
can't.
it is. What is there? That is all.
Very well.
Counsel for the respective parties are present. Full stop. Counsel for the petitioner in GF4 of 2023 has concluded his argument. Full stop. Counsel for the respondent prays for time. In view of the submission made by the counsel for the respondent, let the matter appear on 8th June.
As your lordship, so please.
Grateful to you. And Milord, I have Milord also prayed Milord as way of an interim relief, Milord, stay of all further proceedings.
Nothing
Because
nothing
now
nothing
the
has
interlocutory
formal
court and the
prayer,
short
Milord.
court is not different.
Formal prayer, Milord.
Earlier you can have met because the interlocutory court was
Yes,
different
yes.
and now this in
Yes.
Court.
8 June. 8 June.
Next.
Grateful to you.
12:30.
My lord, I am the plaintiff in this matter, my lord. Here
My
there's an
lord,
Order 7 Rule 10 application taken out by my learned friend saying that this suit ought to be, my lord,
my lord,
plaintiff be returned and for presentation before the non-commercial division, my lord. Here opposition has been filed. My learned
my lord, I
friend-
am praying for a one-day accommodation. My affidavit of reply has not been affirmed. Kindly keep it tomorrow, my lord.
After vacation then.
my
My
lord,
lord can keep it.
Who filed this application? You.
my friend has
My,
filed
I have filed.
application,
This
my
is
lord,
my
the defender.
application.
Law point.
Is
My
exactly
lord, I am
that,
being
my
led by Mr. Joydeep Kaur. That's why, my lord.
lord, may I file my opposition?
Take the position. You will
Lordship
file
is not
reply.
inclined to take it tomorrow, my
My
lord.
lord, reply is not
Ready?
affirmed. That's why.
My lord is not inclined to take it tomorrow, my lord. The difficulty is undefended suit, my lord. Witness action has
When
commenced.
it is fixed.
It has not been
It is
fixed, my lord.
fixed.
It's not been
fixed
fixed.
for-
Let I-
Yes, my lord. It was last day, my lord. It was appearing for continuance of the witness
So
action.
when the next date is fixed.
My lord,
Dates are fixed as on date.
My lord, date was
But at
not
line-
fixed.
Ah.
I filed an application. That's why the matter came in my lord's list.
Okay, I am fixing. First week of the reopening.
Yes, my lord, please.
Counsel for the respective parties are present. Full stop. Counsel for the respondent in GA2 of 2023 has filed affidavit in opposition. Let the same be kept with the record. Counsel for the petition prays for time to file reply. Let reply be filed within a week. Please the matter on 8th June.
I'm grateful, my lord.
Lord, I am for the defendant number 1 and 2.
Should I appear on behalf of the plaintiffs, Lord?
Defendant number 3, my lord, I am the commissioner, my lord.
Lord, today's fixed for Lord taking on record the report of the commissioner. Lord, pursuant to your lordship's order dated 8 February, my lord, the commissioner was appointed. My lord,
Commission is there.
yes, my lord.
Yes, my-
Here before your lordship.
Report is ready.
But my lord, the deposition of the witness has not been, the recording of deposition of witness has not been as yet completed.
Not yet completed.
Yes,
Yes.
Chief is going on, my lord.
Chief
as
of
a-
the plaintiff.
Lord, the
Yes,
chief
yes.
is going on.
Freedom
It will, my lord, 200 pages worth of documents extending into 4 volumes, my lord. Lord, that is the reason it's taking time, my lord. But I have already undertaken before my learned friends that I'll conclude within 1.5 sittings. My lord, thereafter, my learned friends can commence with the cross examination.
February. That's why 3 months was given.
Yes, my lords.
One witness has not been known.
Lord, voluminous documents, my lord. That is the only reason.
My lord, I will keep my defense
I mean, without prejudice to this, I will not make any submissions now because I have already marked objections at the time.
That your lordship will consider.
Counsel for the respective parties are present. Full list of Learned Commissioner is also present. Full list. Today is fixed for filing a report by the Learned Commissioner, but it has been informed by the Learned Counsel for the respective parties as well as the Learned Commissioner. The examination in chief of the plaintiff is still going on. And due to the voluminous document, examination could not be completed and placed for extension of time to file report. In view of the submission made by the counsel for the respective parties and the Learned Commissioner, time to file the report by the commissioner is extended for a further period of 2 months.
Yes, my lord.
2 months is be over.
Yes, my lord, I'll conclude in 1.5 sittings. That's all.
Within a period of 2
My
months.
lord, the cross-examination of the plaintiff perhaps will be over, but there are witnesses from our part also.
For 3 months. Let the commissioner file report. Today we are on May, no? Let the commissioner file report on or before on 21st of August 2020.
Grateful, lord.
Item number 1. The award passed by the Learned Arbitrator dated 12th March 2008 is modified by setting aside the award with respect of the claim number 2, 8 and 14 and the decision rejecting the counterclaim of the railway. Disposed of.
Well, this is appearing at my instance. Your
And for the
lordship was to
defendants
consider-
number 1 and 2.
Your lordship was to consider whether this suit requires to be transferred or not in the commercial division. I had placed before your lordship on the earlier occasion that the contract, if your lordship turns to page number 173, is of commercial nature. Page number 173. This is the contract.
Yes.
So basically, my lord, I'll give in a nutshell what the facts are.
Who is for the defendant?
And I'm for
My
the
learned friend
plaintiff.
is for the defendant.
defendants number 1 and
One and
2,
two.
my lord.
And you are appearing for
And I'm
I'm the
for-
plaintiff. I'm the plaintiff. This is my suit.
You are
Claim is
any
in
objection?
damages.
No, my lord, it should be transferred, but only the defendant number 3 has
Thankfully,
expired. I am-
last day, my learned friend was not there. So your lordship was of the desire that I
That's
should
right.
come back after
for
service.
the transfer of.
My lord, one leave I would be seeking. There has been a change of advocate on record, my lord. There are defects in the written statement. I believe the department has put in some note in your lordship's file. Some leave is necessary, my lord, possibly.
May I take a repeat?
Yes.
Leave may be granted.
Leave and with regard to your
Affidavit and verify,
affidavit and the company has merged.
my lord.
So, but you have not given any resolution whether the earlier
Course.
company has merged with the present company so that you can either you have to take the no objects. If the company is merged, then the resolution should be there.
Vakalatnama, I possibly believe have been filed already.
No, Vakalatnama filed earlier. Now you want that the Vakalatnama in the name of the Niquest.
My lord, that has also been filed. I
That is filed, but there is no resolution whether the Niquest and the earlier company, Ketan, I think.
But I will ask him.
No,
to
it was
put in-
ANS.
I will ask them to put in a new resolution, my lord, or whatever
Resolution
document they
along
raise,
with
my
that
lord.
so that it
And
can.
it will kindly,
I will allow that.
And my lord will kindly give a direction of the
Compliance.
usual compliances.
Counsel for the plaintiff and the counsel for the defendant number
She's for
defendants-
One
defendant
and
1 and 2.
1 and
1 and 2. My lord, 3 has expired. I am
counsel for
told.
the 1
And 3 had not even entered appearance in
counsel
this.
for the 1 and 2 are present. Counsel for the plaintiff submits that though the suit was filed in the year 2014, that is prior to enactment of the Commercial Code Act 2015, and the nature of the suit is of commercial in nature, arising out of a commercial agreement entered between the parties. Counsel for the plaintiff submits that due to the enactment of the Commercial Court Act, the suit is required to be transferred from this court to the commercial division of this court. Full stop. Counsel for the defendant has not raised any objection with regard to the contention made by the counsel for the plaintiff. Accordingly, CS number 100 of 2014 is transferred from this court to the court of commercial division of this court. Full stop. The plaintiff is directed to take appropriate steps for compliance of the provisions of the Commercial Court Act within a period of 2 weeks
2 weeks after you.
after the summer vacation. Full stop.
Grateful.
There is a report. The defendant has filed the written statement, but the written statement requires some amendment. Has filed the written statement, but there are some defects in the written statement. Accordingly, the defendant is granted leave to rectify the defects within a week thereafter, after compliance of the provisions of the Commercial Court Act by the plaintiff. Full stop. The plaintiff is also, and the defendant is also directed to place the resolution of the company to show that the ANS associates have been merged with Nequest Law. NQUEST, Nequest Law, within a period of 1 week after 1 week after a reopening of the court from summer vacation.
I am for the defendant caveat, my lord, in this.
No, to commercial court, yeah, but let the matter appear on compliance of all formalities. Let the matter appear on 5th July before the commercial court.
My lord, this is,
My lord, it's my
My-
application.
yes, my lord, this is my exception to the report. On the last occasion, my lord, the special officers had, the joint receivers had filed a report, my lord. I have taken an exception to that. Now, my lord, today, my lord, I have been served with a copy of an
No,
application.
it's a very, my lord, I'll just tell your lordship what is the matter about. My lord, lordship would recall that in respect of the estate, there were two joint special officers. My lord, one from my side and one from my learned friend side. Now, my lord, both of them sought discharge from your lordship. My lord, now, my lord, the only thing that is required, my lord, is lordship would
No, my
appoint.
lord, there are other things, my lord, I have
In-
said in my exception.
Let it complete. Yes.
My lordship directed us that we should take out a formal application. My application is there before your lordship, my lord. The only thing is, my lord, I let a neutral person be appointed. Because, my lord, I have given the details, because lordship's order is at page 79, and I'll tell you, lordship, in paragraph 17, page 7, my lord, we have indicated that what are the issues that are required to be, my lord, taken care of. My lord, the estate is required to be preserved. My lord, the municipal taxes are required to be paid.
When this court has appointed the
My lord, the order is
special
as at,
officers,
my lord, 4th of May 2015, lordship, the order is at page 43.
yes. Biswajit Kumar and Arif Ali,
Yes.
adequate representing the joint receiver for the purpose of collecting rent. Collection out of the earning of the state of reserve shall pay the municipal statutories, dividend, rental income be kept in a separate account. The interest shall be continued until the disposal of the suit. Yes, only collecting rent.
Yes. Now, my lord,
Sure.
the corporation dues, my lord, though some payments were made, but my lord, payments have accumulated, and my lord,
if the payments are not made, Lordship knows that the statutory authorities might take coercive steps against the immovable properties that are left behind by the deceased. This issue can be resolved. There were two persons representing both the sides. Now those two persons have sought for discharge. Now the only prayer is let a neutral person be appointed. Your lordship will appoint any person.
That's correct, but who will pay? Because earlier the question was the both are the advocate on record, question of payment does not arise. That's why the court has given the both
And
advocates on
if
record.
the remuneration of the special officer is required, lordship will decide what would be the quantum of remuneration. We both will share the remuneration.
That is the objection raised by them.
No, my lord. There are other objections, my lord. If my learned friend has finished, my lord, may I just, my lord? Now, your lordship will kindly, my lord, take his report. My lord, why? Because this application that he has filed, my lord, I want to file an opposition, my lord, at the very outset to this application. Because, my lord, the special officers who are appointed, my lord, they have unilaterally disbursed funds from the estate. Now, this is contrary to the lordship's order, my lord, 4th May 2015.
Report, no, report.
My lord, I have no axe to grind on the fact that a neutral person be appointed. My lord, the payment also, my lord, I have said, let the payment be made personally by the respective parties. My lord, rather than from the estate of the deceased,
Okay,
because
that is enough. So what you want in this,
Yes.
what is the exception to the report?
yes, now my lord will first take his report, my lord will take the order, my lord, of appointment.
That have you gone through then?
Yes, my lord, for preservation of the estate.
Hmm.
Now your lordship takes page 37 of his report.
Yes.
My lord, this is the minutes of the 10th meeting. My lord will kindly take page 38, my lord, the relevant portion. My lord, this is third paragraph from the top. My lord, your lordship is found, my lord, the
Yes.
joint receivers had signed 7 checks towards fees of learned advocates representing the estate of Arun Kumar Bhutoria. My lord, these are his advocates, the plaintiff's advocates. This is a contentious cause.
Perhaps
No,
this
no,
is
no, no.
incorrect.
Now your lordship sees that.
No, this is
I didn't interrupt my learned friend.
No,
Let me finish.
Just let this.
There is nothing to get so angry, my lord.
Now your lordship kindly takes page 40, my lord.
Yes.
My lord, kindly see, this is the second, my lord, this is minutes of the 11th sitting. My lord, page 40, my lord, again, third paragraph. My lord, when I submitted bills for my advocates, my lord, in the same testamentary, my lord, suit, my lord, kindly sees what this says. With respect to the third agenda, Mr. Rajiv Bhutodia and Mr. Sandeep Bhutodia stated that they have not received copies of the bills forwarded by Mrs. Bhutodia.
What I propose to do.
Yes, my lord.
You have given some allegation, whatever it is, exception. Let he deal with the reply on your exception. I will take the consideration of your all these things. But for the interim, now some other has to be appointed.
My lord, I have no axe to. If your lordship wants to.
I will appoint one another advocate, independent advocate. He will do the conditions of the order, earlier order will be remain same. Only with regard to the special officer will be changed. One other.
My lord, I have, my lord, one request, my lord, before your lordship. Instead of appointing one, your lordship appoints 2. Because one, my lord, would be, my lord, because I'll tell your lordship, my lord, a lot of things happen, my lord.
Then it will be burden. See,
Yes.
appointing 2, then nothing. Your learned friends will be benefited, but it is a burden upon the parties also.
My lord, I am agreeable. My client, my lord, is on instructions, my lord, I'm submitting. She's agreeable to pay, my lord, the remuneration of 2 from her private.
Even I am saying that even I am agreeable. Lordship appoints to any neutral person, or lordship will appoint any person, but one person says that the animosity that was there earlier, or the difference of opinions that was there earlier, that can come to an end.
My lord, this is not
we
only
both
question of
must-
animosity, my lord. There have
What
been,
do
my
we-
lord, the estate has been depleted, my lord, contrary to the order. That is my first allegation. My lord, your lordship wants to appoint neutral a party, my lord. I have no objection on that. My lord, I cannot stand in the way.
How the advocate fee will come to the commissioners?
No, my lord, if lordship sees, my lord,
How the advocate will
page-
come to the commissioner?
yes, my lord, page 36. My lord, this was in respect of an appeal. My lord, that was filed pertaining to an order that was passed against the estate.
May I say?
My lord, his advocates, my advocates were not paid.
Okay,
One of the joint receivers, my lord. Lordship, what had happened?
Okay, I
After
will-
we refused,
no,
after
I will
we
decide
refused
later.
to disburse the advocate's fee, Lordship, we said that they are at liberty to file an application. Lordship, my learned friend has filed an application in which certain prayers were allowed. A part of those were the advocate's fee in one of the suit shall be disbursed. Lordship, they were also they were very much at liberty to give their fees, their bills. They were at liberty to give their bills. They gave the bills, but unfortunately, Mrs. Bhutia did not give the bill.
My lord, it's recorded in the minutes.
My lord, only thing, my lord, only one, may I indicate
Bills have
one
been
page?
given.
My lord, kindly
My lord,
take
my
page
client, my lord,
46.
has been, my lord, completely, my lord.
Lordship sees those bills. Those were unfortunately, those were personal, not the estate bills.
What was the date, my lord?
Kindly see, my lord,
My
an
lord, this
officer
is
of
a
court
contentious
is
cause.
here before your lordship saying that those bills do not belong to the estate. My lord, these
My lord, these
submissions
are
should
even,
be
even,
considered to be
even
suppressed.
more, my lord, grave.
I really do
My
not
lord, because he's an
understand
officer of
why my
court.
learned friend is raising his
I
voice.
understand. Okay, he's raising his voice.
Voice power is not directly proportional to the merits of the matter.
Okay, I will decide that. I will decide, and you also file the reply to the exception.
Yes, my lord, kindly see page 46 once. My lord, one page, lordship. Our
46 of
application of GA4, my lord, page 46, an order passed by this honorable court, my lord, 2nd December 2015.
Correct.
Yes, kindly see, my lord, after hearing the learned counsel for the parties, there shall be an order in terms of prayer such and such. Now kindly see the next paragraph. It is made clear that all expenses that are required to be incurred in respect of the litigations as
Which page
mentioned,
you are reading?
my lord, page 46 of my application, annexed E.
Okay.
My lord, the second paragraph at page 46,
All
it is
expenses that are required to be
to be incurred in respect of the
litigation.
litigations as mentioned shall be in relation to such expenses required to be incurred by joint receivers after their appointment. My lord, whatever bills that were given to the special officers or joint receivers, that were, my lord, the bills for protection of the estate of the deceased.
Yes, those are
And
the
my lord,
bills of his clients, of his counsels.
But you are not.
My lord, how is he interpreting an order, my lord? These
Okay,
are
okay,
bills of
that
his
I will
counsels.
decide. I am not going into that aspect. Counsel for the respective parties are present. Police. By an order dated 4th May 2015, this court has appointed Mr. Biswajit Kumar, advocate, and Mr. Arif Ali, advocate, representing the respective parties as joint receiver for the purpose of collecting rent and further to act in terms of the order passed by this court. Full stop. The joint receivers have filed their report, and both the joint receiver not inclined to continue as a receiver in the present case. And accordingly, you are for the petitioner.
yes, my lord, I am the plaintiff.
Accordingly, the plaintiff has filed an application being GA4 of 2023, praying for appointment of a new receiver by this court. Full stop. In view of counsel for the defendant submits that two receivers can be appointed so that the order passed by this court dated 4th May 2015 can be complied with. Considering the prayer made by the counsel for the respective parties, this court find that appointment of two receiver will burden upon the parties for their remuneration, and as such, this court inclined to appoint an independent receiver who is not connected with any of the parties and accordingly you can act. No, my lord, I am a part of Khaitan and Company. Part of Khaitan and Company, who is having 10 years of experience in the matter. You can. You are not connected with any of the parties. Not connected with any of the parties. Any objection?
No, my lord, I leave it to your lordship, my lord.
I cannot have, my lord, never had an objection to this.
No. In open court, I am appointing.
My lord, it is, my lord, your lordship's, my lord, graciousness that your lordship is asking this question that whether, my lord, he's connected. My lord, if the receiver is not connected, my lord, I have no objections to it.
So and so, give your total details. So and so is appointed as receiver of this, receiver in the instant case by replacing the receivers appointed by this court by an order dated 5th May 2015. Full stop. The conditions of the order dated 4th May 2023 remain unchanged. 4th May 2023.
Your lordship will kindly clarify, my lord, no other exceptions out of, no other payments, expenses will be made, my lord, apart from what is particularized in that
Remain
order.
unchanged, and the receiver shall act in terms of the order dated 4th May 2015.
Grateful.
2015.
My lord, only thing, my lord, kindly make orders, my lord, because there is another order of at page 46. Instead of order, my lord, kindly makes orders passed by this honorable court.
4th May.
Yes, and my lord, there is another order, my lord, at page 46, the 9th,
May 2015
2nd December
and-
2015
and
order.
2nd December 2015.
Grateful.
And 2nd December 2015. Full stop. The full stop. The joint receivers have filed their joint report, and the defendant has taken exception to the said report after serving the copy to the counsel for the plaintiff. Full stop. The plaintiff is given liberty to file reply to the said exception within 2 weeks after reopening of the court after summer vacation. Full stop. Let the matter appear on
বলে দিচ্ছি।
26th June.
My only thing, my lordship will relieve, my lord, the joint
The-
receivers.
My lord,
The-
just one thing, my
as-
lord, before your lordship passes that order. My lord, I have made, my lord, serious allegations against these.
That's why I given the.
Your lordship, my lord, that will have to be taken into account because.
That's why I fixed, given the chance to file a reply so that I will take the.
Don't pass these comments, Mr. Ali, please. No, no, don't.
No, not in court, not in court, not in court. Not in court. That will be decided by that's why I given chance. You have given, make an allegation. I have given chance to file a reply.
Absolutely.
Let the matter appear on 26th June.
My lordship is
I'm grateful.
discharged or lordship, because my lord, if my lord, your
Allegation.
lordship's officer steps in, my lord,
No, that's why, because there is an allegation, let it, I am not passing on your discharge, let it be decided on merit.
I am grateful.
They,
my lord.
they have been, but
then my lord, there, the problem will be that, my lord,
Full-
if
the joint receivers have been discharged for the time being, and in future, if required, this court will pass appropriate order for
Yes.
their presence,
I'm grateful.
for their presence.
grateful.
Honorous.
Expect this from Mr. Hari.
Leave it. Notice board, please.
Remuneration has not been fixed.
Yes, yes.
Remuneration.
Yes, my lord, I leave it to your lordship, my lord.
Yes, what about the
I
remuneration?
leave it, my lord, upon your lordship, my lord. I cannot comment on that. This is.
What is the rent? Give that, and give the report. What is the monthly rent you are collecting? What is the total amount of the rent month?
The problem is the new rental agreement has not been fixed.
Okay.
They want to sit with the receiver, just because you're wanting discharge. The areas, there are quite a lot of areas there. Because the new agreement has not yet been entered into, because of delay made by the bank.
My only thing, my lordship would kindly make any sum fixed by your lordship, whether it's on a monthly basis or my lord, a lump sum basis, my lord, that your lordship will.
For the present, the remuneration of the London Commission is fixed at rupees 30,000. And after taking into consideration, the further remuneration will be decided.
My lord, this is per month. Your lordship has fixed this, my lord.
For 13.
Absolutely.
30,000.
My lord, only thing is, my lord, let this money be paid, my lord, out of the private pocket, my lord, not from the estate. That your lordship will kindly clarify, my lord. That was my prayer. for you.
Then it can 50,000. Let to 50,000, and the said will be paid by both the parties in two
Equal.
equals.
Grateful.
Very well, grateful, man.
50,000 for the time being, and the same will be shared by both the parties in two equals.
Grateful deeply.
Grateful.
ठीक है 50.
My lord, I'm appearing for defendant 1 and 4, my lord.
Lordship, appearing for defendant number 2. This is my application. This is an application, Lordship, for appointment of receiver. Despite Lordship,
Before that, on last occasion, your lordship called for a report from the Registrar General with regard to the pendency of the suit, my lord.
It was showing disposed of for some reason, my lord.
And your lordship also directed to list all 3 GA pending GAs, my lord. My lord, only 1 GA is appearing.
Report has come. So what was the settlement arrived between the parties earlier?
In the settlement.
In terms of the settlement, the suit was disposed of.
My lord, the preliminary decree was passed.
Yes, my lord. Yes, my lord.
A preliminary decree.
Yes, my lord. Wrongly, that was recorded and the suit was disposed of, my lord.
Yes, preliminary decree. Dispose of the GA, but they have taken as a total suit.
Has to be. And my lord, there are 2 other applications which my learned senior friend rightfully pointed out. Both filed by the plaintiffs. One is GA 803 of 2019.
803.
803 of 2019. And the other, my lord, GA 270 of 2020.
2020.
The first one is 803 of 2019. The second one, 270 of 2020. Now, if I may just indicate, in the first application of 2019, the pleadings are complete, at least from our side. The defendants, defendant number 1 and 4, my lord, they had filed their opposition.
No, on the last occasion, GA 4 of 2019, GA 5 of 2019, and GA 6 of 2019 are pending.
Oh, my lord.
GA 6 of 2023, my lord.
GA 6 of 2023. And GA 4 of 19 and GA 5 of 19.
Subject to correction, perhaps these are renumbered. The ones which I just
If
said
it is
must be.
19, 20, 23, yes.
Yes. Now, GA6 is an application taken out by defendant number 2. Well, I choose to file my opposition to that before.
That is a new application.
New application.
And what about the earlier application?
Earlier application in the first one, 2019 application, we have filed our opposition.
What are the said application? 219 application?
Yes, my lord, I'm just indicating.
What is the 19 application? Manutas, GA has come. But GA has not come.
Yes, in the 2009 application by the plaintiff is for appointment of a commissioner to effect the partition. 2020 application, my lord, appointment of a receiver to collect the rent and the valuables of the estate and discharge the liability functions. And GS6, my lord, appointment of receiver again by defendant number 2, subject to correction with regard to their portion or their allocation. Now, in GA
in the 2020 GA, that is GA 270, opposition's direction was passed on us. But somehow or the other, my lord, we could not file it. It's ready. It has been ready since then, but we could not file it. So that has to be first taken into consideration, and we choose to file opposition in the new GA as well. The problem, if I may say so, there are a couple of properties regarding this estate.
So what has happened to the preliminary decree?
Essentially, all of us were to comply or
Correct.
complete the whole thing within 3 months. Now 3 months have passed long back. There were certain obligations which all were supposed to met in regard to KMC tax, staff gratuity and all those dues, and my lord, income tax outstandings. Now they were huge sums. We had meetings. Plaintiff were present, but I don't think my learned friends clients were there in those meetings, which was indicated, my lord, we will pitch in funds. Now somehow then COVID came in. The whole exercise became stagnant. Now in the meantime, KMC has attached the properties in order to fetch the rents and settle the dues, and they are running in crores.
Then who paid the pen?
Now all the properties, the source of income is rental income. So the rents, a chunk of it is now going to the KMC directly to settle the dues against the properties. The remaining portion, which is there, is being distributed to all the partners or parties in this manner, if I may say so, as per the shares. Previously, when the attachment was not there, the rental was quite a sum. It was distributed accordingly. Now that the attachment has taken place, every month, subject to correction, few lakhs is going to KMC directly. Still, there is a lot of dues. My clients had pitched in.
First, you complete your preliminary decree first.
If I may say so,
That is actually the prayer in the GS6, my lord.
Now,
or a special officer can be appointed.
Certainly, my lord, this is
Now-
what they are saying, that according to the proportions, respective proportions of the parties, they are giving us the money which we are responsible or we are entitled to, my lord. My lord, how can they decide what I'm entitled to? We don't even know what
No,
they
no,
are
no, no,
actually
no.
collecting.
Subject to correction, my lord, the ratio.
This is the reason, my lord, for this, they are holding the entire property, my lord. And
No,
he
none
is
of us are
saying,
holding.
my lord, the defendant, answering defendant 1 and 4 are saying that a small portion of the property is into their custody, my lord. And a chunk of the property, a large chunk of the property has been seized by the KMC. My lord, this is totally incorrect according to our statements. Certainly, my lord.
Once the preliminary decree has been
Now-
accepted by all.
Certainly, my lord, that is there.
Now, in order to satisfy the preliminary, yes, my lord, I bow down to your lordship. The obligations are to be met by all.
No,
My client, my lord.
I don't think by sitting together,
My lord.
it will be. Let the special officer sit with the special officer or any of the person.
In
so
that
they can-
case, if I may humbly beseech your lordship, my lord, before my lord takes such a decision, my lord, may I
No,
file?
I
my
am not taking reason. It is
if I may file my affidavit. And one more indulgence, my lord, let the other applications also come in the list. My lord, it will be
already has.
Oh.
Already there. 19 also
a,
there.
those are not listed as per the cause list. So
Not listed.
no, my lord. Only GA6, my lord, filed by defendant number 2 is there.
J6 already.
And my
there.
lord, one indulgence, my lord, in spite of writing the plaintiff, my lord, they have not supplied me the copies
My lord,
of
we
the
have the
application.
copy, my lord.
What copy?
My lord, copies of the pending
Yeah.
applications. Yes,
My
my
lord,
lord.
Other two.
this is our application, my lord. We are serving with the copy, my lord.
This is one, my lord, one more, my lord. I am
The other applications are not filed by us, my lord. Probably it's their application or something like that, my lord.
Filed by the plaintiff, my lord.
Counsel for the respective parties are present. The registrar original site has submitted the report wherein it reveals that
My lord, the plaintiff is
The-
not represented today, my lord.
plaintiff is not
No.
there.
My lord, we had a talk with them,
You are appearing for?
my lord, for defendant number 2, my lord.
I am for 1 and 4. My learned for the last 4-5
Then
occasions, they
appears
are
on behalf
absent.
of the plaintiff. Full stop. Counsel for the defendant number
1 and 4.
1 and 4. You appearing for
My lord, 6, 7 and 8, my lord.
1 and 4, 6, 7 and 8 and
2, my lord.
defendant number 2 are present. Full stop. The London Register Original side has filed a report wherein it reflects that, wherein it is mentioned that as per the computer system and in the ledger of the concerned department, the date of disposal of the suit is shown as 15 December 2017. Full stop. After going to the order dated 15 December 2017, passed by this court, it reveals that as per the terms of the settlement signed by the parties and their learned advocates on record, this court has disposed of GA number 2373 of 2010 by allowing a preliminary decree in terms of the settlement. And the application being GN number 2373 of 2010 was disposed of. But inadvertently, in the computer system, it is shown that CS number 194 of 2010 is disposed of. Accordingly, the computer department, the registrar original site is registrar IT is directed to take appropriate steps for deleting the status of CS number 194 of 2010 as disposed of, as the said suit is still pending for final disposal. Full stop. Counsel for the respective parties submit that there are 3 applications are pending, being GA 4 of 2019, GA 5 of 2020, and GA 6 of 2023. As in connection with GA 4 of 2019 and GA 5 of 2020, pleadings have been completed.
No, well, I've just received the.
But the pleadings are not complete in GA6. None of us have filed our opposition.
Are pending. Full stop. Now, what is to be done? GA4. Who has filed the GA4?
Plaintiff.
So it has not been served.
Not been served.
We have received, but I believe
I have requested him to serve me a copy, my lord. He has not, my lord.
Counsel for the full stop. Counsel for the defendant number 2.
6, 7,
6, 7, and
8, my lord.
8. So, and you are received.
My lord.
GA4.
My lord.
Counsel for the 6, 7, and 8 submits the counsel for the defendant number 6, 7, and 8 submits that he has not received the copy of GA4 of 2019 and 5. You have received the 5.
My lord, 5. I've received.
You got to be 5.
803 of.
803 of 2019.
No, my lord, not even 5.
That is a 4. 803 is 4. And another is
5. 803 is 4, my lord.
270.
No, my lord.
No. Plaintiff, the counsel for the defendant number submitted he has not received the copy of the GA4 of 2019 and GA5 of 2019. Have you received the GA6?
My lord, we have served it.
No, my lord.
Here and now,
Yes.
Here and
I'll just receive now.
4 of 2019 and GA5 2020, and only today he has received the copy of GA6 of 2023. Full stop. The plaintiff is directed to serve the copy of GA4 of 2019 and GA5 of 2019 to the defendant number 6, 7, and 8 within a week from date.
In regard to my lord, GA3 of 2020, which was 270, GA 270 of 2020, my lord, the opposition was ready long back. On the next day,
He has not filed.
No, defendant 1 and 4. My clients, we had formed the opposition in regard to the plaintiff's second application. Can we file that on the next date, my lord?
Okay, I am giving the time to file, complete the pleadings.
Very well.
I am opening the to all the parties.
I'm grateful.
Full stop. Within a week from date. So the defendant 6, 7, and within a week from date. Full stop. The parties are directed to complete the pleadings in connection with all interlocutory application within 4 weeks from date.
Can it be from reopening? It's a voluminous task.
Within 4 weeks from the reopening of the court after summer vacation.
Grateful.
Great.
full stop. Let CS number so and so 194 of 2010 along with GA 4 of 19, comma GA 5 of 2020 and GA 6 of 2023 be listed on 5th July 2023.
Much obliged.
Next.
Your Lordship, I appear on behalf of the petitioner. It is my PLA matter, Your Lordship. The date of demise of the deceased was on 25th of November 2017. Thereafter, Your Lordship, the respondent, that is the widow of the deceased, made certain withdrawals. On the previous occasion, Your Lordship had directed the respondents to file a supplementary affidavit with regard to the withdrawals that the widow of the deceased has made. Your Lordship, they served us with the supplementary affidavit. We have filed our opposition. They were supposed to file their reply. We have not yet received the reply yet.
There was no direction possibly to file any reply. We would be needing.
Your Lordship, it was there, order dated May 1st, 2023. Your Lordship would see.
Counsel for the petition press for extension of time to file affidavit in opposition to the supplementary affidavit.
Yes, there was a direction. I stand corrected. There was a direction. There was a direction.
Within 10 days. You will file the reply or?
We'll file the reply. But only one thing, may I indicate? There's really a fight between the widow, who is the respondent, and actually the brother-in-law. The mother-in-law is the petitioner, but that's the actual fight. The
I
widow
object,
is
Your
only
Lordship. I
surviving.
object. That is a really vile accusation. It is not a fight.
The widow
is not going to dispose of anything now.
Yes. And the citation of this proceeding has not yet been issued. And what the parties are constantly doing is they're keeping on exchanging affidavits and filing applications after the other. Widow is basically surviving on the corpus which has been left by the husband and the interest generated from that.
So who are the parties?
Parties are the mother-in-law of the mother of the deceased and the
Who is
wife.
the
Of the
executor?
There is no, it's without the will.
Without the will.
Without a will, it's a letter of administration without a will.
Your Lordship, if I may.
Filed by the mother.
Mother.
Mother of the deceased.
Mother of the, and deceased died by leaving behind wife.
The wife and the mother and a daughter.
Minor child, Your Lordship.
So, it has to be divided into three. There's no dispute on that. Now, allegations are that I have withdrawn some money. The widow.
So why it has not been settled? You are
Exactly
appearing
my
for the-
point. This is not a luxury litigation. None of the parties
You are
can
appearing
afford.
for
Your Lordship, I'm for the mother of the deceased.
mother of the
The
deceased.
petitioner.
And you are appearing with the wife and
For the
daughter.
widow.
The widow.
For the widow.
And the
Daughter is not a party. She's a minor.
She's the minor, whatever it
Yes.
may be. So sit together. So what is your contention?
Your Lordship,
You want
our
the total?
contention, Your Lordship?
We want the total.
No, Your Lordship. We are agreeing to 1/3 distribution of the assets equally among all the three heirs, the mother, the widow, and the minor child. Your Lordship, but they are saying that let it be distributed in piecemeals. Your Lordship would see GA3. They have categorically stated in their GA3
What are the
application.
assets?
Your Lordship, there are immovable properties, there are movable properties as well. Your Lordship, they are seeking for piecemeal distribution of the assets.
Yes.
But we are saying the assets
You
in
are
its
ready with
entirety
you
should
are
be.
ready for the three.
Yes, Your
one-third,
Lordship.
one-third.
Yes,
You
Your
are
So
Lordship.
am
for
I.
that.
So
Of
am
the
I.
all property.
Of everything.
Of entire property,
You-
Your Lordship. but
Same thing.
it
We are
must be
agreeable.
taken
My
as a
application is
whole.
only for.
You do one thing. You bring the other your client. You bring your client. I will take the evidence. It will be disposed of. No problem.
Very
Yes.
well.
I will record the evidence of
Absolutely.
your client. I will record the evidence and I will
Everything
dispose of
will be over for
Very
once
well,
and
Your
for
it. Need
all.
not to go for any
Yes.
G application, interrogatory
Absolutely.
application.
And
I am fixing a date and time. Let mother and daughter-in-law
Yes.
come here.
Absolutely. Let them come.
It
Very
will be
well.
done.
But
Very
only one thing with regard to the application which my learned friend was appraising your lordship about, it's not a question of piecemeal partition. What we were wanting is there are two flats which are lying idle. So what we had proposed that let these two flats be sold and the shares be distributed. That's the one thing.
That's why let
But
it
Your
come.
Lordship, the widow has already made
Let it
withdrawals.
come. I will record the evidence and I will pass an appropriate order. If you wanted to, both the parties have wanted to sell the property, I will appoint a commissioner. The sale proceeding can be done and
Absolutely.
Your Lordship, kindly sees the opposition that we filed to the supplementary.
I don't
affidavit.
want that to
We
be
have made a
disposed of. They
chart.
are wanting
Your
this to be
Lordship, may I, Your Lordship, please. Your Lordship, we have filed
our opposition to the supplementary affidavit wherein we have annexed a chart. That chart is based on the admitted records, the admitted statements made by the widow of the deceased. Your Lordship would see the widow of the deceased had actually violated the orders of the court time and again, Your Lordship.
What order was passed by the?
Your Lordship, the court was pleased to direct the widow to file a supplementary affidavit wherein they furnish the details of what all withdrawals they have made after the demise of the deceased till the first hearing, from the first hearing till date.
How the withdrawal has been made, in whose name the amount is playing?
Your Lordship, the deceased.
So how
But then the widow of the deceased is claiming it.
so how
in-
it was withdrawn?
Your Lordship,
How it was withdrawn?
Your Lordship, they have not made complete disclosures with regard to the same.
Okay.
That is my very contention, Your
I
Lordship.
am
Your-
passing an order, let the both the party present in person before this
Yes.
court.
Before that, may I indicate only two things? The allegation is I have withdrawn some amount. What I have done is I've given account for that. And if it is going to be partition 1/3 each from my share, that would be deducted.
That's why.
Simple.
let both the
It is
party-
not some amount
Whatever
That's why,
amount,
madam, let-
of the 70
even if it's
crores.
100 crores from my share. it will be
Fine, let
deducted.
first your evidence may be recorded.
Very well, Your
Court may
Lordship.
pass an order and it
Very
will
well.
be reflected. Let the evidence, you put the question, whatever it you want.
Absolutely.
If it's admit, automatically order will pass a recovery. If you got,
Right.
she got the excess amount, it will be recovered
Yes.
from her.
Fair
Or
enough.
you will get the
From my
more
share.
Fair enough.
and
Yes, Your
they will
Lordship.
get the less.
Yes,
That's
Your
all.
Lordship.
That's
Yes,
it.
Your Lordship.
Simple thing.
Your Lordship. Your Lordship, additionally, I want to state another thing. Your Lordship, on the previous occasion, the other side had said that we are not taking any steps regarding the citations to be issued. We have spoken to the department. All the formalities have been
Let us see till
processed.
next date. Let the both the party appear.
Your Lordship kindly passes an order for issuance of citation.
If the both the parties are ready to settle, why the citation?
Okay, very well.
There
Very
is no third party.
very well.
The
Very well.
letters of administration.
Yes.
Without
Yes.
a will.
Without a will,
Yes.
nothing.
Both the parties are agreed for that. Why
Yes.
the citation and all these things?
Very well,
Both
Your
the
Lordship.
party come here.
Absolutely.
Very well.
Counsel for the respective parties are present. It is fine from the submission of the respective parties. As all the parties are ready to settle the issues for getting the share distributed amongst them in three equal share. And accordingly, this court find that the case can be disposed of by taking evidence of the parties before this court. Accordingly, both the parties are directed to appear before this court on 7th July at 2 p.m. for giving their respective evidence.
Grateful.
Time 12:30.
No, well, 2 p.m. 2 p.m.
2 p.m. 2 p.m. is there. Come with your client.
Yes.
Evidence will be taken. Cross-examination will written. Whatever the cross, come with the cross-examination also.
Much obliged, Your Lordship.
See, we were opposing this application unless by Mr. Banerjee.
Item number.
CA8.
Yes.
Actually, this is that application for recalling Mr. Jishnu Shah had completed his submissions.
Yes.
Lord, kindly look at the order, my lord. It's not a question, my lord, where, my lord, there could be a recalling, because, my lord, this was considered by my lord, and, my lord, on grounds mentioned, my lord, this has been.
Where is the order passed by this court?
Yes.
One volume 2, 165.
My lord, 165, my lord, is the
Volume 2 of GA8.
order. It's not, my lord, as in, my lord, this was dismissed, my lord, for non-prosecution.
Yes.
165, my lord, volume 2. So, my lord, a suit of 2014, my lord, a trust challenge to a trial. I'll show, my lord, the other orders. By order dated 165, by order dated 23rd December 2021, this court has granted liberty to the plaintiffs to cure defects with a condition for payment of cost of 1 lakh within a period of 2 weeks from date as condition precedent. As per the report filed by master and official referee dated 19 January, which reflects the plaintiff did not take any steps in the suit, and no cost was paid in terms of the order dated 23rd December 2021. Master and official referee has again submitted report on 21st April 2022, intimating plaintiff has partly cured the defects and paid the cost. Today, when the matter was called, counsel for plaintiff again pressed for time to cure the defects appearing in the plaint. Counsel for the defendant raises objection and submits that the suit was filed in 2014. Yet 2021, this court had granted liberty to the plaintiffs to cure the defects. In spite of liberty granted by this court, plaintiffs had failed to cure the defects and had also not taken any steps for issuance of writ of summons upon the defendants till date. It reveals from the record that the suit was filed in 2014. By order dated 8 May 2014, plaint was admitted subject to scrutiny by the department. On scrutiny of the plaint, altogether 8 defects were pointed. In spite of the same, plaintiff has failed to cure the defects. Vide order dated 23rd December 2021, coordinate bench of this court permitted to cure the defects, but in spite of specific direction, plaintiffs failed to carry out the same. In view of the above, this court is of the view that the plaintiffs have filed the suit only to harass the defendants and to drag the matter. Hence, this court has no other alternate but to dismiss the suit. Accordingly, Sansa is dismissed. Consequently, connect house into an is vacated.
Yes.
So this is not it's question not a question of recall anymore. But I understand, if it's a question of a review of an order, that's different. But this is not. The prayer, if now looks at kindly similar the application, the prayers which they have made, I don't know how they could have made this, if I may use the expression, the jumbled up at page 25. And the order of dismissal was 20th May 2022. And this application is filed only at least we were served on November 2022. Can you see volume 1? And page 25 says delay in preferring the incident application be condoned. Order dated 20th May 2022 passed in CS number answer then
20 May and filed on September.
Sorry,
Filed on September.
Oh, September. November.
Affidavit is September.
I don't know when it was filed, Malad. I don't know when it was filed.
28th September.
Filing also, Malad,
20th September. Filed on 20th September.
So, Malad, that is also, Malad, beyond, Malad, from May to September, Malad, that is also, Malad, beyond, Malad, June, July, August, 4 months later. Because we were, Malad, only served in November. But can you look at, Malad, the reliefs? I don't know how this kind of application, Malad, is maintainable. Page 25, Malad.
Yes, I am there.
Malad has seen the delay in preferring the instrument be condoned, order dated 20th May passed in connection with and be recalled.
Yes.
Malad, there is no scope, Malad, for recalling of an order and passed after consideration of Malad, the facts. And they were present. Civil suit number such along with be restored to its file. The defects in the plaint.
Whether it is maintainable. Application is maintainable. Application is maintainable.
No, Malad, it will not be. Because it's not, Malad, an order 9, Malad, rule 13. Next. Because, Malad, it is, Malad, something, Malad, which was considered and, Malad, not, Malad, for non-prosecution. And then, Malad, D, E, and F, Malad, kindly see, Malad, they also, Malad, asked for
restoration.
Yes, then, Malad, defects in the plaint as pointed out by the department in paragraph 42.b and the Sansas be annexed, be dispensed with. Then, alternative, prayer D above. Department be directed to accept the affidavits, then leave be granted. F is leave be granted to. Suit has been dismissed, and Malad, all these Malad prayers are made.
Okay.
Then Malad, there is Malad, I can show Malad those interlocutory orders which were also passed. Malad, where Malad, the interim order Malad was vacated at page 108.
108.
Yes, Malad, 108.
But Mr. Banerjee, I have two.
Yes, Malad, I am told Malad has Malad.
Division bench.
Malad, we can't Malad detail Malad. Malad,
I am fixing
after
vacation.
After vacation, Malad.
She fixes a date, Lordship.
Any day convenient, Malad.
Yes.
Malad, 5th, we are opening Malad, 5th, 6th, 7th.
They are asking on June.
Oh.
But June first and second week, I am not here.
Oh, no, my lord.
Whenever.
Then
After
I
that-
am fixing in July.
Yes, yes.
Council for the respective parties are present. Full stop. The council for the respondent has started his argument, but due to some personal difficulty, but the same paucity of time, hearing could not be completed. Let the matter appear on 14 July at 2 p.m.
14 July.
at 2 p.m.
Highly applicable.
Lord, the only one, my lord, item 10, my lord, we can, my lord, that is also, my lord, by between the same parties.
Is
So,
my
my lord, we can
application
file
for
affidavits.
amendment. My learned senior friend can file his affidavit and
Affidavits,
we
my
can
lord, we'll
come
file.
back.
Item 10.
Item 10, I'm sorry, my lord, to trouble.
No, item 10, you are for the petitioner.
I am for
My
the
learned
petitioner.
friend is for the petition. They want an amendment of, my lord, I don't know how they
Affidavit
ask
of
for it.
assets.
So what is the
Affidavit
time?
of
What you want to do now?
That is
We
my
have-
application for amendment. If my learned senior friend wants to file an affidavit, we can come back.
I'm for the plaintiff, my lord, they want amendment of affidavit of assets.
10. Council for the respective parties are present. Time to file the respondent is directed to file affidavit in opposition within 2 weeks after vacation. A reply, if any, they are to be filed within a week thereafter. Let the matter appear on.
Same date, lordship, if possible.
Yes.
Let the matter.
14th.
Then 4 weeks, 2 weeks. 4 weeks, 2 weeks, 14 July.
Grateful.
Highly obliged, lordship.
Is at 2. At 2.
Please, your lordship, could I be permitted to make a mentioning?
At this stage.
Your lordship, my learned colleague had mentioned in the morning, we did not have a copy of the order. If I could just see your lordship.
Come tomorrow, man.
Please, your lordship, take your pledge.
দুটোই হয়ে গেল।
দেখে নিয়েছে
may I permit to mention the matter CS number 158. So degree has been passed. Requisition has not been filed within time. Leave be granted to file the
When the decree was passed,
8th May.
8 May this year.
One day, this only one day.
Please, ma'am. This is kept for the evidence of the caveator. The exam, the witnesses here.
Yeah, proceed.
My lord, may permit Mr. Ghoshmai Jr. to ask the questions.
No. Huh? Yes, yes.
I solemnly affirm
I solemnly affirm
whatever I depose
whatever I depose
by the way of evidence,
by the way of evidence,
I shall speak truth.
I shall speak the truth.
No part of it
No part of it
shall be false.
and
I shall not conceal anything.
and I shall not conceal anything.
Your name?
Parthasarathi Bhattacharya.
Your father name?
Jyoti Prakash Bhattacharya. Late Jyoti Prakash Bhattacharya. 56. Practicing advocate at this honorable court. 527 Jodhpur Park, Kolkata 68.
Mr. Bhattacharya, how do you spell your name?
My name has 13 letters. Parthasarathi ends with a Y and not an I.
Please spell it.
Partha, middle name Sarathy, and last name Bhattacharya ending with JEE.
That's it?
Yes.
Mr. Bhattacharya, what is your connection with this suit?
I am the defendant in the suit, the only defendant.
What are your professional and academic qualifications?
After completing my BCom degree in Mumbai, I qualified as a chartered accountant in the UK.
Go slowly.
Yes, yes.
Whilst in the UK, I received the LLB degree from the London University and was also called to the bar at Middle Temple Inn. Middle Temple Inn.
Middle Temple.
I am a fellow of the Chartered Institute of Arbitrators, UK.
What is your present occupation?
I am a practicing advocate of this honorable court. From time to time, I undertake arbitration work outside of Kolkata.
Are you aware of the facts of the instant case?
Yes.
Can you tell-
This case concerns an alleged will of my father, which is sought to be probated by the plaintiffs, who are third parties and not related to our family in any way. My contention is that the document that is sought to be probated is a forged document and not the genuine will of my father.
What is your father's name?
My father's name is Jyoti Prakash Bhattacharya.
Is he alive?
No, he passed away on.
The relevant question is released.
In the examination chief, without a leading question, I can ask whatever I want.
Yes, please.
Is he alive?
No, he passed away on 7 November 2009.
How old was your father when he passed away?
He was about 81 years old.
What was your father's educational qualifications?
My father received the BSc degree from the Calcutta University, after which he was conferred the LLB degree from the erstwhile Earl Law College, Guwahati, Assam.
What was your father's occupation?
My father was a senior advocate for many years at the Guwahati High Court. He was also the Advocate General of Nagaland for over a decade. He later moved his practice to the Supreme Court of India. For some time, he also practiced at this honorable court.
Was he a member of any of the bars?
He was a member of the Supreme Court Bar Association, aside from which he was a member of the Guwahati Bar Association.
Mr. Bhattacharya, I'm showing you a document which has been disclosed, a copy of the document which has been disclosed as DD9 at pages 71 and 72 of the judge's brief of document. What is this document?
This is my father's Supreme Court Bar Association card. It has his name and membership number and his permanent Kolkata address, 527 Jodhpur Park, Kolkata.
Who has made the photocopy of this document?
I have.
Did you compare the photocopy with the original?
Yes, I did.
Do you have the original?
It is with my advocates.
I am showing you the original of this document. Can you say what is this document?
This is also his Supreme Court Bar Association card from the year 2005.
I'm showing you another. May I tender this document as an exhibit?
May I have an inspection of the documents?
And they have already had, man, I'm giving inspection.
Your lordship may tender the photocopy and
I will
record that
return.
we will take back the original.
Given the return.
You can see the originals. Leave be given to bring back the original.
Leave be given to take back the original, my lord. The exhibit 5.
Exhibit
5.
Exhibit 5. Yeah, chief, no? These are defendant number 1, na?
I am for the defendant.
First witness.
No, this is there were documents which were exhibited through the plaintiff's witness 1, 2, 3, 4.
During cross-examination?
During cross-examination.
We had got a essay, the handwriting expert went first.
Yeah, that was exhibit 1.
Exhibits 1 and series. And some of the documents we have exhibited through. That's why exhibit 5.
See the exhibit list.
Photocopy.
No, see by 5 there. Exhibit 1. And this one. Exhibit 2, exhibit 3.
71 and 72 collectively 5.
No.
এটা আলাদা।
Exhibited C. Where is 1? Exhibit 1, 2, and 3. There is no 4.
There is a 4, man.
Which one?
There
Where
is it is the exhibit 4 is but it's a money receipt, my lord, which was exhibit 4. 3 and 4. 4 is DD2.
Yes, exhibit 2. Exhibit 4, subject to objection, money receipt. Yes, exhibit 5.
Mr. Bhattacharya, I am showing you another copy.
Record that. Just a minute. The original identity card was produced
71 and 72 of the judge's brief of document.
উপরের পার্টটা না নিচের পার্টটা বলবে 5
এটা হচ্ছে নিচের part, এটা হচ্ছে এইটা দেখিয়ে দিলাম, এটা হচ্ছে এটা
Lordship, the judge's brief of documents at
Activate?
page 70,
Page?
page
71,
71,
72 has got
two
two
documents
documents.
being shown. So they are being separately exhibited, I believe.
No, that is only one dot 71.
Yes, it is two
71 and
documents.
72, there are two documents, my lord.
No, you have produced the
I am producing a Xerox, that's why.
no, no.
The original also.
The original identity card was produced. That is one document.
Yes,
That's why.
yes,
That is page 71.
71.
71.
Not
70,
75.
71 top part.
That is
Top
what I'm
part.
saying. The
Because
front
it is two parts.
Two
Yes,
parts,
yes, yes.
Two documents in one page.
Top
front
part, now I'm
page
showing
is
the bottom part.
72 is the back side of the
Document,
document.
bottom part of the other document. It is other identity card.
It's another identity card.
So then this part is to be exhibited.
So that therefore I'm giving a separate Xerox, my lord. The Xerox has been exhibited.
Okay. Given this separate.
Yes, yes.
So you give serve the copy to other side also.
I will. Yes. What is this document? It is not been. No, এটা তো হয়নি.
That is page number?
There are two documents.
Which page?
71, the bottom part.
This is another Supreme Court Bar Association card of my father.
Who has made this photocopy?
I have.
Where did you get the card from?
It was in my father's records.
Did you compare the original with the photocopy?
Yes, I did.
Where is the original?
It's with the advocate.
I'm showing you a document. What is this document?
This is the original of this photocopy, which is the identity card.
May not the same leaf be given to take back the original?
Original.
I tendered
Original
the Xerox.
identity card along with Xerox was shown to the witness. Witness identified the same. Accordingly, Xerox copy of the identity card is marked as Exhibit 6
photocopy
after comparing with the original, and original identity card is returned to the London advocate for the defendant.
May I have my lordship's leave for? Yeah. May I have my lordship's?
Yes, next.
At the time of the death of your father, do you know who his legal heirs in intestacy would have been?
His legal heirs then would have been my mother, his two daughters, and me.
What is the name of your mother?
Chitralekha Bhattacharya.
Where did your mother reside during the lifetime of your father?
My mother always resided with my father, first at Guwahati, Assam for many years. Thereafter, for some time in Delhi, and since the mid-90s at their Kolkata residence at 527 Jodhpur Park.
How was your relationship with your parents?
I had a good relation with my father and mother and had their affection.
In the year 2007, where was your father residing?
By then, my father was residing at his permanent residence in Kolkata, 527 Jodhpur Park, Kolkata 68. This house was constructed in the early 80s. So this was his only permanent residence in Kolkata.
Mr. Bhattacharya, I'm showing you a document, copy whereof is appearing as DD10, pages 73 and 74 of the judge's brief of document. Please tell my lord, what is this document?
Photocopy. This is a Kolkata Municipal Corporation tax bill. The relevant year is 2007, and it is issued to my father.
This tax bill is in respect of which property?
The tax bill is in respect of the property belonging to my father, which is 527 Jodhpur Park, or also addressed as 1/527 Gariat Road, Kolkata.
This pertains to which period?
This, as I said, was for the relevant year of 2007, 2008. So it lists 3 quarters of 2007 and the final quarter of that financial year in 2008.
Can you say whether this is the original document or not?
Yes, this is the original tax bill which was issued by the Kolkata Municipal Corporation.
From where did you obtain this document?
This was in my father's records.
I tendered this document as an exhibit.
Exhibit 7.
It's a record. Original. Please tell my lord, what was your grandfather's name? That is the name of Jyoti Prakash Bhattacharya's father.
My grandfather's name was Jyotish Chandra Bhattacharya.
Did your father own any property other than in Kolkata?
My father also owned a plot of land in Kalyani, which was under long-term lease from the government of West Bengal.
Mr. Bhattacharya, I am showing you a document, copy whereof is appearing as DD3, pages 24 to 32 of the judge's brief of document. Please tell my lord, what is this document?
Page number?
Pages, my lord, 24 to 32.
My lord, this is a certified copy of the lease deed in connection with this plot of land in Kalyani belonging to my father.
From where did you obtain this document?
This was obtained from the department, which is the Register of Assurances. It's dated the 13th of December, 2019.
Who has obtained this document?
This has been obtained by my advocates.
Who has instructed your advocate to obtain this document?
I have instructed my advocates to obtain this document.
Is it certified copy, my lord? So it can directly go in.
Exhibit 8.
Please give this. Yes, I want this argument document. Mr. Bhattacharya, can you identify your father's name in this document?
Yes, it's on the first written page. Jyoti Prakash Bhattacharya.
Mr. Bhattacharya, please encircle the portion identified by you as your father's name by red ink.
Yes.
Let the portion be tendered as.
The whole document is exhibited.
No, only the portion as 9/1.
The name appearing, this father's name of the witness appearing at exhibit 6.
No, my lord, it's
Exhibit 8 is marked as exhibit 6/1. 8/1, sorry. 8/1.
Can you find in this document the name of the father of Jyoti Prakash Bhattacharya?
Yes, it follows the name of my father, son of Jyotish Chandra Bhattacharya.
Can you please identify the portion by encircling with the red ink?
Yes.
That portion. my lord.
The name of the grandfather of the witness appearing in exhibit 8 is marked with the red ink circle is marked as like 8/2.
Mr. Bhattacharya, in the year 2007, where were you residing?
I was then living in London in 2007.
Did you have the occasion to visit your parents in 2007?
Yes, I had quite a few occasions in 2007. I got married in 2007. So I first came down in January of 2007, after which I came down also in February and March, and in May and August of that year. Finally, I came down in December with my wife. So yes, I had quite a few occasions.
Where were your mother residing in 2007?
She was
Where was your mother residing?
as I mentioned, she was residing with my father at 527 Jodhpur Park, Kolkata 68, which was their permanent home.
How was your father's mental and physical health at that time?
My father was mentally okay. By then, he was wheelchair bound. His mobility had been severely restricted by his ailments.
Did your father execute any will during his lifetime?
My father executed his last and final will in the year 1995. He first had a draft will, which was then finalized and executed on 24th April 1995. This was his final will and testament.
Did anyone take any steps to for the probate of such will?
Yes, me and my mother applied for letters of administration in connection with this will. This was in March of 2011.
Yes, ma'am.
There were no executors in the final will executed, so we applied for letters of administration. Sorry.
Can you tell my lord the case number of that probate application that you referred to just now?
That is testamentary suit TS 11 of 2013. This was after the PLA application of 45 of 2011 was marked with a contentious cause and became a testamentary suit.
Mr. Bhattacharya, I'm showing you a document, copy whereof is appearing as DD5 at pages 39 to 46 of the judge's brief of document. What is this document?
This is the final will, last and final will of my father, executed on 24th April 1995.
Is this the original?
This is a photocopy.
Who has made this copy?
I have made this copy.
Did you compare the copy with the original?
Yes, I did.
Is this the true and correct reflection of the original?
Yes, it is.
Where is the original?
The original has been submitted in the proceedings TS 11 of 2013.
My lord, that TS 11, just for your lordship's matter, is appearing together with this matter. These two matters are appearing together. My lord, may I tender this document?
That the original
No, you
since
see the
then it's
11
already
11
executed.
is here.
Yes,
The,
Lordship, the
it's,
records are
remember,
there.
it's already an exhibit in the other matter.
Okay, you go through, then it can be compared.
I'm just exhibiting the photocopy of that.
Photo-
Rajit.
The original is there.
Photocopy is telling that exhibit is in other suit is there.
Yes,
Let it be shown to the witness.
Okay,
Yes,
I will.
And in that context, Lordship, may the copies, Lordship, of the petition as well as the written statement that has been filed subsequently by the daughters, the copies of the pleadings maybe, and with
Of
the
which suit?
Lordship, the other suit where the witness has filed, Lordship, that the documents may be tendered to us, Lordship.
No, they are not a party to that suit.
We are not, Lordship. Now the two suits are being heard together.
Together, but you are not the party in that.
I
You are
am
not
the
appearing.
parties,
You are not
Lordship,
appearing.
but now Lordship, the will in that probate proceeding is being referred, or Lordship is being tendered as evidence in this proceeding. Now my interest in I have a will, subsequent will, in respect to which I have filed in probate.
Correct.
I have an interest, Lordship, to know, Lordship, what has happened.
But you are not appearing in the matter, madam.
I am not appearing,
Not
but the two
appearing.
suits are
Two suits are,
analogously
that suit
being
has,
heard.
that suit is being contested by other party.
Lordship will allow me liberty to
My
upload
lord,
certified
my lord,
copies of
only
what-
one thing.
Lordship,
Only
by-
one thing, my lord, in a probate matter, a person who doesn't have a caveatable interest is not entitled
No,
to
that is
get the
different thing, but you have not made any application, you are not the party to the suit.
No, I have.
Correct. So how it can?
Lordship, only the liberty may be granted, Lordship,
What?
to obtain certified copies.
That always,
Very.
always,
I shall.
you can apply for certified
Right.
copy.
Right.
Who has restrained you?
Well, may I show this? I am showing you a document which is a part of TS number 11 of 2013. What is this document?
This is the original will of my father, the last will and testament of 24th April, 1995.
Can you say whether you have made the photocopy from this original?
The photocopy is made from this original, yes.
Let the photocopy be marked.
The copy of the will, photocopy of the will is marked exhibit
Copy that.
9. After comparing with the original will lying in TS number 11 of 2013. The copy of the will be marked as exhibit. It's already given 9. Already given.
Lordship, may I be permitted to have a look at the
Yes, you know.
What is the status of the said TS 11 of 2013?
After my mother's passing away, the application had to be amended when I became the only applicant. Thereafter, my sisters contested the application when it was marked as a contentious cause and became a testamentary suit. The suit has been ready for final arguments since 7th June 2018.
When did your mother pass away?
My mother passed away on 17th October 2011.
Did your mother execute any will during her lifetime?
Yes, my mother executed her own will on 29th of January 2010.
What happened to that will?
I, the executor, as executor, applied for the probate of that will. And such probate was granted by the Honorable Court on 3rd of March 2017.
I'm showing you a document, copy whereof is appearing as DD6 at pages 47 to 55 of the judge's brief of document. What is this document?
This is the last will and testament of my mother from 29th day of January 2010.
Is this the original?
No, this is a certified copy.
From where did you obtain this certified copy?
It was obtained from the department on instructions to my advocates.
Which department?
This is the testamentary department.
Of which court?
The testamentary department of this honorable court.
Repeat ended manner.
Exhibit 10.
Give it. It will be marked. Give it. I'm showing you another document, copy whereof is appearing as TD7 at pages 56 to 65 of the judge's brief of document. What is this document?
This is the grant of probate in respect of my mother's last will and testament.
Is this the original?
No, this is a certified copy again obtained from the department, the testamentary department of this honorable court.
Repeat ended manner.
Exhibit 10. 11, sir.
During the lifetime of your father, did he mention about the alleged will of 2007, which is the subject matter of this proceeding?
My father never mentioned about the alleged will of 2007.
Did your mother mention of any such will executed by your father?
There's a leading question, Lordship. Earlier question was a leading question.
Yes. The
Maybe
question.
withdraw that.
I said, my lord, that during the lifetime of your father, did he mention about the alleged will of 2007 being the subject matter of these proceedings?
That is the cross.
Lordship, he cannot indicate what is the answer is. Is an alleged will, Lordship.
So, my lord,
Any will, not alleged will. You cannot put.
sorry, the next question. ওনাকে বলুন।
My mother never mentioned such will of 2007, such a alleged will of 2007.
Do you know whether your mother had any knowledge of any such will?
My mother had no knowledge of such alleged will of 2007. She was co-applicant with me in the PLA 45 of 2011 for the grant of letters of administration in connection with my father's last will and testament, where she has confirmed on oath that the 1995 will was the last will of my father. In her own will of 2010, she has also confirmed that the 1995 will was the last will of my father. She had no knowledge of the alleged will of 2007.
May I show, my lord, the exhibit 11, which is the certified copy of the mother's will? না এটা নয়, will এর কথা। 11 না, তাহলে এর আগেরটা 10।
ওইটা না,
প্রপার দেখি কি হবে? মানে shown exhibit 10.
Exhibit 10 shown to the witness.
Can you, since you have just now said that in your mother's will, she has confirmed the 1995 will to be the last will of your father, can you indicate the portion from the copy of your mother's will where he had said so? Sorry, she had said so?
Yes, that's on page 2 of the last will and testament of my mother, and that's the first 2 lines.
Can you please read out the first two lines which you're referring to?
Yes, my husband, Sri Jyoti Prakash Bhattacharya, made his last will and testament on 24th April 1995.
Do you know the plaintiffs of this instant suit, Kiran Chandra Bodai and Kanchan Bodai?
I don't know such persons.
Did your father ever mention these names to you?
My father never mentioned such names to me. Neither did my mother. I cannot think that they knew such persons.
Did your father ever mention the name of Khogendra Chandra Bodai?
Sometime in 2001, my father mentioned the name of a person by the name of Borai in connection with a plot of land in Kallani belonging to my father.
Do you know Mr. Khogendra Chandra Bodai?
Yes, I have had the occasion to meet him a few times after the passing away of my father and mother.
When did you meet him?
As I recall, I met him sometime in 2015 or 16 in connection with this plot of land in Kallani belonging to my father.
Where did you meet him?
He came to my residence at 527 Jodhpur Park with repeated requests to meet me.
What were such requests made by him?
Sorry, can you repeat?
What were the requests made by Mr. Bodai to you?
He mentioned that there was a plot of land in Kallani which was to be transferred to him, but that the transfer had not taken place. And that I should assist him with this transfer.
What was? Sorry.
I recall mentioning to him that there were proceedings in respect of my father's last and final will, and that I could not assist him then until the proceedings were over.
What exactly was the assistance that he sought for?
Then he was looking for some assistance to complete the transfer. As I said, at that point in time, with the proceedings pending, I was not able to assist him. Subsequently, he made other visits with requests to see me. At that time, I was not living in Kolkata, but my family was here. He came repeatedly, and he did not register at the gate. In my absence, he came several times. And finally, when I met him, he requested for copies of the death certificate of my father and mother. He said that the concerned department in Kallani was prepared to transfer the plot of land belonging to my father to him if he was to furnish those copies of the death certificates.
Did you provide him with the death certificates?
Initially, I did not provide him with copies of such death certificates. He kept coming back in my absence. Finally, I asked him for a copy of the agreement to show whether there might have been any transfer in connection with the plot of land belonging to my father. He provided a copy of an agreement of transfer, after which I gave him copies of the death certificate of my father and mother.
During these meetings with Khogendra Chandra Bodai, did he mention about the alleged will of 2007?
He did not mention about the alleged will of 2007. About the alleged will of 2007.
it has been alleged by Hogendra Chandra Barai that the death certificate of your father was provided by you after some 3 years from the request he made. What do you say to that?
On the request.
From the
Which
date
he
of
made
the
to you.
that he made.
I have already explained the circumstances in which I provided to him copies of the death certificate in good faith. I regret I provided him copies of such death certificate. I was then living out of Kolkata, and after his request was made, it took some time for me to verify the facts in a situation where I did not know the person or the transaction as such. I categorically deny that I provided him the death certificate 3 years after his request. This was done within a few months, given that I was then living out of Kolkata. Given that I was then living out of Kolkata.
When did you first come to learn about the alleged bill of 2007?
On 28th April 2018, I was sent summons to my Kolkata residence, and this summons contained a copy of the alleged will of 2007.
Did you get the opportunity to see the original of the alleged will dated 5th July 2007?
Yes, after I came to Kolkata together with my advocates, I took inspection of the alleged will of 2007 in the testamentary department.
Upon inspection, what were your findings regarding the said alleged will of 5th July 2007?
I was shocked. The document had a number of erasers and interpolations. I could see from my naked eye such in interpolation and erasers. My grandfather's name was incorrect and my name was misspelled.
What steps did you take thereafter?
I lodged a caveat on 11th of May 2018. I wrote a letter. I sent in writing to the registrar that a forged will in connection with PLA 270 of 2017 had been submitted to the testamentary department. I submitted my affidavit in support of caveat on 17th May 2018.
Since you have said that the alleged will dated 5th July 2007 is a forged document, now I am showing you the original of the alleged will. Not the original. Your Lordship will keep the original with yourself, with your Lordship, my Lord. Your Lordship will keep, I'll give a colored photo. No, man, I just want your Lordship to also see. No, I just want your Lordship to also see. This is my Lord, this is a colored photocopy of the same original. Kindly say.
Does it have markings on it? Or?
Yes, it has.
Can I hand up a copy
It's,
with
it
markings?
has been marked by Honorable Justice Bhattacharjee, my lord. It's also there.
Marked copy into
It's also there.
witness.
I will go through. You give the original.
In the original, there are also markings, my
Maybe
lord.
that's why, otherwise. Yes.
Shown the original, man. Can you please identify and tell my lord, according to you, what are the marks of forgeries in this document? If your lordship, please see.
It is a color. Is it?
A Xerox one? Oh.
The large blank space at the start of the will seems very irregular. On the first page, I suspect it is to fit in page 5, the contents of page 5, exactly after page 4. On page 2, at the second paragraph, the date of the will is inserted after a big full stop. A big full stop. This appears to be an interpolation. The margin of the 6th line is also not aligned. The spacing between the 5th and 6th lines are not uniform. 5th and 6th lines are not uniform. My name is misspelled on page 3 and 4. As I have said, my name ends with a Y and not a I. Ends with a Y and not an I. My father has never stated my name incorrectly in any document. It is inconceivable that he would have done it in his testamentary. Inconceivable that he would have done it in his testamentary instrument. Coming to page 5, one can clearly see the erasers in connection with the words testator and witnesses. It is retyped, to me it appears, on transferor and transferees. At the top of the page, the number 5 is of a different type font to 5 elsewhere on that same page. It is also clear that the page number 5 has been typed after erasing on that space. The alleged will appears to have been drafted by an advocate whose name has been concealed. The back page of the, sorry, one moment. At the bottom of the page, where it says continued 6, is inconsistent with the previous page, which says continued P/5. P/5. It clearly appears to me that page 5 is an interpolation and has been added to this document. The back sheet of this alleged will is also highly irregular.
Please come to page 5 of this alleged document. Can you identify any of the signatures in this page to be the signature of your father or your mother?
I cannot confirm these signatures. As I have said, this is a forged document and not the genuine will of my father.
Apart from the marks, please come to the first page of the document.
Yes.
The name of the father of Jyoti Prakash has been written as late Nishikanto Bhattacharya. What do you say about that?
My grandfather's name was Jyotish Chandra Bhattacharya. That can be seen from the death certificate, provided by the plaintiffs in this proceedings and from exhibits made earlier. The Salt Lake address mentioned here cannot be understood by me. By then, as I have said, my father was permanently residing at 527 Jodhpur Park. Permanently residing at 527 Jodhpur Park, Kolkata 68. Such address is already mentioned in his will of 1995, his last will of 1995. So thereafter to mention a Salt Lake address, thereafter to mention a Salt Lake address seems to me to be highly irregular.
Apart from the marks of forgery that you have just now said, why do you say that the alleged will was not executed by your father?
As I've said, my father was a renowned senior advocate. He had profound knowledge of the law. He was well adept at English language. I cannot think that he would have authored a document with such serious irregularities in it.
Yes, please.
I have already referred to my father's last and final will of 1995.
Yes.
Which was first drafted in his own hand, and his writing is evident therefore, a copy of which is submitted in the testamentary proceedings TS 11 of 2013.
I'll show exhibit 3, my lord. Exhibit 3 technical. Exhibit 3. देखिए हाँ, I'm showing you a document which has been already marked as Exhibit 3 in the instant proceeding. How did you receive this document?
As I mentioned, my lord, when the attesting witness in the instant proceedings concerning the alleged will of 2007 approached me with a request to have copies of death certificates of my father and mother, I asked him to show me the agreement of transfer. This is a copy of that agreement of transfer, which he provided to me at that time. The agreement is dated from 15th of April, 2001.
I'm drawing your attention to the last page of this document. What do you say? What do you have to say to such page?
I find a striking similarity between this unnumbered page and page 5 of the alleged will of 2007.
Affidavit, caveat. Give it. Affidavit in support of caveat. I'm showing you a document which is a part of the record of this instant proceedings. Please tell my lord, what is this document?
This is the affidavit in support of caveat. The caveat I filed on, I'm sorry, this is dated the 17th of May, 2018.
Please come to page 21 of this document.
Yes.
Can you identify the signature appearing thereat?
This is my signature. I have signed it.
Who has drafted this affidavit?
This has been drafted by my advocates under my instructions.
Are the contents of this affidavit true and correct?
They are true and correct.
The plaintiffs have filed the suit for the grant of the probate of the alleged will dated 5th July 2007. What do you say to that?
I'm astonished. No probate should be granted in respect of this will. A forged and fabricated document has been put forth before the court. And this is not the genuine will of my father. No probate should be granted in respect thereof.
I'll take my lord maybe 15 more minutes. I'm led by Mr. Ghosh. He might ask questions. Your lordship will fix another day. Or if I do not have any questions, they can start their cross-examination.
Ready with the cross-examination? Yes. Next date. Next. I shall start. I do not know whether I'll be able to conclude.
Okay, please start.
Thank you.
Next is probably after the
July.
Your lordship kindly fixes this, my lord, as your.
I will fix
Yes.
fixing.
June. In the month of June, my lord.
June, I don't think so. You will get in July, that too also last
July.
not be available.
Actually, he has got certain professional assignments for which he'll be traveling. So if it starts in the July, then if it spills over in the June, if it spills over to July,
Let
then
me see the date.
just some date in mind.
Let me see the
June.
diary. Yes, take that. Counsel for the respective parties are present. Defendant witness number 1 examined in part, and during his examination, how many documents have been exhibited? Exhibit 5 to exhibit 11 were exhibited. Full stop. Due to paucity of time, examination could not be completed. Fix. When? July, not June. 345. You will take risk in June, then 345 I will fix.
345 is very risky.
And that's why.
Not there in July.
He will be traveling for an arbitration to Delhi and
Ask the dates, which dates?
June, any date before.
30th June at 3 p.m. 30 June at 3 p.m. for further examination in chief and cross examination.
Grateful to your lordship, madam.
Next, fixed matter.
This is my application, my lord.
But I'm opposing this application.
The application before your lordship is GA5, my lord, in connection with the suit.
GA4, GA5.
GA4 and GA5, my lord, but GA5 being an application for impounding, my lord, that needs to be heard first. And GA5, my lord, flows from GA4 because I'll give a background, my lord.
So GA5 is to be taken first.
Yes, my lord. GA5 is to be first. Well, this is a suit for eviction which was filed by the plaintiff in respect of a property at Loudon Street. This suit is based on a notice of section 106 of the Transfer of Property Act. Now, in connection with the suit, GA4, my lord, is an application filed by the plaintiff for payment of occupational charges. Now, when that application was filed on the basis of certain agreements, certain documents which were there, an affidavit to that was filed by the defendant. In the affidavit, several agreements were disclosed by the defendant claiming rights over the property. In fact, it was a stand of the defendant that they are no longer the tenants, they have acquired rights in respect of the property in question. Now, these agreements are all in the nature of insufficiently stamped instruments, and therefore, since they have relied upon these agreements, we have taken out this application GA5, asking for, my lord, seeking impounding of these agreements, since, my lord, they have relied upon it. And, my lord, your lordship, I'll, of course, once I go take your lordship through the facts, I'll cite the law also. At any stage, my lord, this can be, my lord, impounded. And it need not be marked as exhibit also for that purpose.
Now, what is the stage of the suit?
My lord, the suit, my lord, can't proceed, trial can't proceed, because, my lord, we have filed an application for letters of administration in respect of the property, because this property originally belonged to my grandmother.
Correct.
Now she has expired, my lord. Thereafter, my lord, I have been substituted. Initially, another person was substituted who had filed an application for grant of probate. Thereafter, my lord, that probate petition got dismissed. Thereafter, this present plaintiff has been now been impleaded as a plaintiff, substituted as a plaintiff. Yes, he has been, my lord, the plaintiff stepped into the shoes, but then there is a specific order by this honorable court that till, my lord, my letters of administration case is decided, the trial in the suit can't commence. In fact, if I may show your lordship, my lord, that order, that is at page 10 of my application, GA5. Order of 8th April 2021.
Yes.
My lord, may I place this order? Page 10 of the application. J5. By this application, the applicant seeks substitution of the original plaintiff. Learned advocate appearing for the applicant submits that upon the original plaintiff passing away, the executor of a purported will of the original plaintiff got himself substituted as the plaintiff. The probate application filed by such executor was dismissed for default on March 14, 2018. On the basis of the registered will of the original plaintiff, his daughter, as the executrix, applied for probate. She renounced her executorship. The applicant took out an application in the letters of administration proceeding. Learned advocate appearing for the defendant draws the attention of the court to the earlier order passed on the application for substitution. He submits that the same embargo may be provided in the event the court is pleased to allow the substitution. In the facts of the present case, the substitution proposed is on the basis of an application for grant of letters of administration of a will of a deceased. In such circumstances, there will be orders in terms of prayers A to E of the master summons dated March 26, 2021. It would be appropriate to place the same embargo as passed earlier on July 21, 2011. The suit will not be tried till such time letters of administration is obtained, or else if the letters of administration is refused, the suit will not be proceeded before the intestate heirs of the deceased are brought on record. Hence, my lord, the application was disposed
I
of.
just want to make a small submission. I'm not standing in the way of my learned friend's submissions. But I respectfully submit, considering the fact that there is an embargo on the hearing of the suit till the letters of administration proceedings is disposed of, my lord, by making these applications in the suit, my learned friends are just, my lord, trying to reach closer to the goal by getting final orders in the suit. So in my very humble and respectful submission, this should not be heard now. Let my learned friend take steps in the letters of administration. They have not taken any steps whatsoever to get that matter heard, kept it pending. So till that matter is heard, my lord, kindly, my lord, I would respectfully.
What is the stage of the administration?
It is a
Pending its court proceeding is going on, my lord. It is as a contentious cause. The matter is as a contentious cause, my lord. The proceeding
That
is.
should be proceeded.
Well, that will be
So
proceeded.
why this application?
My lord, these applications, my lord, no, my lord, is an
See.
suit for eviction.
Suit for eviction, whatever it is. The court has passed an order. This is to be kept in abeyance, whatever it may.
My lord, the trial only.
Why?
Yes,
Trial.
yes, only the trial.
Now you wanted to produce the original impound. If you got the order in the administration suit, so what purpose would be served here?
My lord, may I indicate this, my lord? In a proceeding for eviction, even now the Honorable Supreme Court is also, my lord, the judgments are very clear, and occupier has to continue making payment of occupational charges as per the last paid rent. My lord, today, just because the eviction suit is pending, the defendant is enjoying the property for years without making payment of any occupational charges.
You have not made any application.
Yes, I have paid. That is my GA4.
Okay.
In respect of that application, in the opposition, certain agreements, my lord, were disclosed by the defendant, which, because they are all insufficiently stamped instruments, because the defendant are claiming rights over immovable property, there are in the nature of agreements for sale, agreement for pledge, which all requires a particular stamp duty to be paid.
Correct.
And therefore, my lord, since now the
stamp duty will come into effect if they wanted to bring on record by exhibits at the time of evidence. Or if they didn't want to put the witness on dock, if they wanted to argue it on merit on the basis of the document, then the question of with regard to the impounding, registration, whatever it is, it will come. At this stage, if you wanted to bring on record and impound, what purpose would be served?
Well, now even I would
Because this
try
is
to
not the case
satisfy.
that they wanted to rely upon that document without producing any evidence.
Well, I would try to satisfy your lordship on the point, and I'll also show judgments on the point. The fact that even at an interlocutory stage, an agreement or a document which is insufficiently stamped, that can't be looked into till the time it is impounded.
Can't be looked into.
Yes.
Because now they are not relying upon any document had this
They
here.
have relied upon.
Where?
In their opposition to my application
Which
for
application?
GA4.
GA4.
Which is also pending before your lordship.
Okay.
Now
So
that's
you
why GA5, I have filed this
Okay,
application.
they will not impound. You argued on that it is not impound. It cannot be taken into consideration.
now
How can impose a condition to impound it? If they are not impounding, it is their burden.
If they're not, it's brought before your lordship, my lord. Since something has been brought before your lordship, my lord, the law, even as per NN Global, the latest 5 judgment, that it has to be impounded, my lord. Now, that's because they took the chance of bringing the same on record.
What NN Global says is to be impounded if
Yes.
the document relied upon. Correct.
Yes.
It relied upon. And you are telling that the GA4, you have filed an application GA4 for remitting the amount before the court, depositing the amount before the court, or receiver, whatever it may be. I have not gone through. And they have relied upon some documents. You said that that document is required to be impounded. Without the impounding, that cannot be taken into consideration. That is the merit of that GA application. If they will not impound, you can take the plea. The court will decide whether impounding is necessary or not. How you can say that it is to be impounded?
Well,
If it is, you can raise the point, and the court will decide as it is impounded. The no order can be passed. Let them impound.
Well, this is that's the reason I'm taking this point by way of GA5.
Okay.
Because
with regard to
well,
once the suit has been installed,
now
trial is installed.
My learned senior friend, my lord, has taken this point now. I mean, at this stage, but then there was another application.
I wanted to put the question in the meantime, Mr. Bose has.
Yes, my lord, Mr. Bose has taken this plea as to why we are moving applications, but then your lordship has disposed of another application for perjury, my lord, few days back in connection with this.
But that was not brought on record.
No, all these three applications were there.
This order was not brought.
No, my lord, this order was, all these applications were there. In fact, I mean, this application was being heard, my lord, with the other applications. Now, Mr. Bose, my lord, with great respect, he did not take this plea, my lord, when the other application being G number 6 was being heard.
Because it was being heard on the basis of pleadings, affidavits.
So that's also on the basis of pleadings.
No,
not the suit.
It's also, my lord, on the basis of documents in the application.
No, that is in the document of the application, but you wanted to one immediate relief on that ground. 340.
340. Yes.
Remember that 340 application that was dismissed, whatever it may be. Now the trial has been stopped.
My lord.
Can the document is impounded or not? Whether at this stage it can be taken into consideration after the order passed by the court.
My lord, may I try to satisfy your lordship? Here, trial is to stall till the time, my lord, the letters of administration is granted in my favor. If it is not granted in my favor, then, my lord, the interstate successor steps into my shoes. In the meantime, my lord, in a suit for eviction, the defendant is occupying a property for many years without making payment of any occupational charges.
Correct.
Now, they can't be allowed to occupy and just keep on, and they're running a business from there without making any payment. For that, my lord, we as a plaintiff have a right of occupational charges during the pendency of the suit. We made the application being J number 4 for payment of occupational charges.
Correct.
Their defense to the application is that they have obtained rights over the property on the basis of certain agreements. Moment, my lord, they brought that on record, my lord, before this court by way of an affidavit which they have filed before this court, my lord. I have taken the objection, because they are all insufficiently stamped instrument, that first these agreements have to be impounded. Because once it has been brought to the records of court, then without, my lord, first impounding.
Whether your defense will be a good for directing them to impound, or whether your defense will be good if that has not been impounded, it cannot be taken into consideration. Which defense will be better?
My lord, impounding also puts a lot of fiscal pressure on the defendant.
Your question is, your submission is that has not been impounded, it cannot be taken into consideration. That's why impounding is necessary. So if it is a specific defense, so you can take the defense in for what document relied upon. It cannot be as per the Stamp Act. It is to be impounded. They have not impounded. It cannot be taken into consideration. The court will decide on that.
My lord, since the document was before your lordship, my lord, is in terms of section 33, my lord, read with section 35. The court has to impound these.
I am not on that with regard to it, not. But whether at this stage you can say impose the condition can be imposed, you have to impose that. Tomorrow, suppose they are not relying upon the document.
Well, if GA4, my lord, is taken up with the GA5 also, my lord, that is
your choice. This is your choice. You have taken the GF5 before GF4.
But my lord, if since my lord they had, because in GA4 also that is their defense. So the issue will come up.
Maybe
As to
that the court will decide whether without impounding the document, the court can consider that what the defense they have taken.
Well, I get what is falling from your lordship here, my lord. Well, then in that even my lord, may I come back on another date,
Take
my lord?
instruction.
I'll take instructions, my lord.
Take
In that even if GA4 and 5 together can be heard, my lord, and because consequence will follow, if lordship feels it's requires to be
That's
impounded,
why
that consequence will follow.
if you have a specific objection to the affidavit in opposition, you might have been filed the reply.
Yes,
with the
and also
opposition.
we have taken out of application.
You might have been filed the reply. You might have been taken that plea that it cannot be taken into consideration because it has not been impounded. As per the section 33 to 35.
We are given a reply to yes, GA4. No, GA4. Yes, affidavits are complete in respect of GA4. GA5, my lord. Yes, the GA5, the AO, the
Take
stat.
instruction. If you want to argue, you argue. If you want to take instruction, you take instruction as per your choice.
There is not much time left today in any case, my lord. My lord,
We'll keep it after the vacations.
So I
and
am
kindly
fixing a date.
fixes a date, my lord. Will it be my lord's pleasure to mark it part heard?
Not yet start hearing.
Very well, very well. Very well.
Counsel for the respective parties are present. Full counsel for the.
I have no objection if it is kept part heard. I leave it to my lord.
No, but it is not.
It's entirely up to
Counsel for the plaintiff petition in GA5 of 2022. Press for time for taking appropriate instructions. Accordingly, hearing of the application is adjourned. Let the matter appear on 21st July at 2 p.m. 21st July at 2 p.m.
21st July.
21st, 2-1. At 2 p.m.
I'm very grateful.
My application, my lord.
Yes.
My application for amendment of asset, my lord.
You are the lucky person. You got the time. 18.
Returnable on 18.
18, my lord. No respondent is there, no consent.
Whatever it may be. Come on 18.
Yes. Yes.
Number 7.
Last occasion I deposited the stamp, but I have got the stamp Friday. Go to my landed, go to the department. Department says file is not here. Go to court and decide the matter. Here is stamp meter. Accepted me. Now High Court suffers from copy of stamp meter.
Yes. Where is the challan?
Everything is here.
So what is this?
Everything. I have.
So now what you want?
Non-contested application disposed of this.
So it is in your hand. Why you not submitted?
I have got the last Friday. I mean 12.
File it.
You are the sole authority, can take it and dispose of the matter. Not contents of application, can dispose of the matter. I am coming and going.
No, but unless and until the department will.
Department is not allow your lordship.
On 3rd May, you stated that it was deposited. You are not given the copy. When you are deposited, when you purchased it.
3rd May I have deposited.
So they said
department by tomorrow. Let the matter appear day after tomorrow. File it tomorrow. And the file may be sent to the department.
Lordship, this matter has been kept for correction. The judgment dated 4th May 2023.
What correction?
Lordship, on the second page of the judgment, first paragraph, it's reading Ashit Kumar Bhattacharjee left behind 3 daughters, namely Shudhamoy Bhattacharjee, Annapurna Bhattacharjee, and Urmila Bhattacharjee, 2
And the
granddaughters.
order was passed. 4th May.
Yes, Lordship.
No, it is coming today.
Lordship, it had come on the list on Friday as well, wherein we had commenced recognizing the corrections that are required. Thereafter, Lordship was pleased to keep it on Monday to be mentioned.
No, on that day, somebody other advocate had appeared. He told me that he will take file application. Some other
Lordship, it
advocate
had last appeared on Friday.
There are several corrections. Or it has done. Vijay Devi? That was my one. No, that is different. That is Aloka. And here also some other advocate had appeared.
Lordship, I mean, led by Mr. Dasgupta in this matter, he had appeared before your Lordship on Friday, but thereafter, this is the first occasion that it has been listed since last Friday.
Things 2020, 2022. Where is the file is there? Let the file come tomorrow. You come tomorrow, stop up the list.
Lordship, just small leave I'm praying for is I have made a small note for the corrections I'm seeking and relevant paragraphs in GA3 that has been filed before your Lordship.
GA3?
Yes, Lordship. GA3 of 2023. It's an amended petition which correlate for all of the citations that have been issued on the remaining heirs that returned deceased.
So what has happened? What is the order? Can you see that order? This order. This has been disposed of. So what
Yes,
is
Lordship.
GA3?
4th May's order, Lordship. There are certain corrections that we are praying for.
Yes.
And this is just a note with respect to the areas that we are praying for the correction in and relevant paragraphs in GA3, which will correlate the same corrections. Because on the last occasion, Lordship was had placed certain questions with regard to the corrections that are being sought for.
That's why I'm asking. There some deliberation was there. I could not. You do one thing. Come tomorrow with the file.
Sure. Much obliged.
Your Lordship.
What about 10?
Lordship, I'm for the petitioner. The advocate on record couldn't appear today due to some personal difficulties.
Okay.
I'm praying for an adjournment today.
Give the file. Give the file. Why the restaurants? What is the restoration?
Lordship, I'm just praying for an adjournment today.
I am dismissing it. Restoration application adjournment.
Can you fix it tomorrow?
Sorry. You all wasting the time of the court. Item number 11.
Lordship, kindly fix it tomorrow, Lordship.
No, it is it is another other file. 11 is GA2.
Yes, I am dismissing. Because after receipt of the notice from the defendant also you are not appeared. And you are filed an application for recalling. Now today again you are asking for the time. Who is your senior?
Mr. Singh.
Who's saying?
Something Singh.
Take down. The present application being GA2 of 2023 is filed for recalling of the order dated for January 2023, passed in GA1 of 2022, wherein this court has dismissed the GA1 of 2022 and dismissed the suit being CS number 122 of 2019 for default. Full stop. It is fine from the order dated 4 January 2023. The matter was listed on 29 November 2022, but none appears on behalf of the plaintiff. And accordingly, the case was adjourned. And again, the matter was taken on 4 Jan. Case matter was adjourned with the rider that in case none appears on behalf of the plaintiff, in spite of receipt of the notice, appropriate order will be passed. Full stop. The order dated 29 November 2022 was duly communicated to the defendant number 1 to the plaintiff by the counsel for the defendant number 1 and 8, informing the date of hearing of the suit. But in spite of receipt of the notice, none appears on behalf of the defendant on 4th January 2023. Plaintiff on 4th January 2023. And now the plaintiff has filed the present application, praying for recall of the order dated 4 January 2023. This court finds that several opportunity was given to the plaintiff. Even the counsel for the defendant has informed the date of hearing to the plaintiff and have filed the affidavit of service. But in spite of the same, the plaintiff was never bothered to appear before the court to represent the suit. Accordingly, this court did not find any reason to recall of the order for recalling of the order dated 4 January 2023. Accordingly, GA1 of 2023 is dismissed. 1 of 2023, 2 of 2023 is dismissed. Next.